the June 18th meeting. The reason offered for removing the restrictions were due to a school zone on County Road 25. But we know County Road 25 and US Highway 27 run together right out here on the highway, and that could be an exception. Just throwing the baby out with the bathwash isn't appropriate there. You can still have an ordinance prohibiting haul trucks from going through school zones. A note could be added to the no school zone restriction that states County Road 25 running with US 27 is exempted. Item B, specific recommendations. And I tell you, these are just going right up and down the ordinance, as I think y'all would probably have already done in preparation of this meeting, just to identify the things in the ordinance that just don't seem right. On page 3 of 14, general requirements at the top of the page, add to the end of the paragraph that special exemptions for mines that access county roads will not be reviewed, processed, or approved. Item 2, page 3 of 14, introduce a new no mines will be approved when the distance between the mine and the existing mine is 10 miles or less. Change the existing number 1 to 2. Page 3 of 4, item C, now marked out prohibiting trucks through school zones should be reinstated even if such needs to exempt school zone at County Road 25/US 27. Page 8 of 14, water use. In the two places where 200 feet is written, please change 200 feet to 300 feet. Page 9 of 14, 12, haul route. If both places were approved, is subject to approval by P&Z, please add after planning and zoning and subject to BOCC approval. Item 6, page 9 of 14, please include the language recommended above regarding landowner property operator financial responsibility for costs incurred by the county in attempting to get the surety to pay up and road repair costs that exceed what the surety pays. In this section, please add that all decisions made by the Community Development Director regarding performance, security, financial issues are subject to BOCC and/or county attorney review and approval. Page 11 of 14, dewatering. Please change the quarter mile to 1/2 mile. Page 12 of 14, please change 25 feet to 300 feet. It is not practical to even think about digging a mine within 25 feet of a jurisdictional wetlands. Thank you.
So we have one from Robin.
Yes. Reading on behalf of Robin. Good morning, my name is Robin McLaughlin and I reside at 1311 Crisdale Avenue, Muse, Florida. Though there is much to take exception to and show opposition of in the mining ordinance that you will act on today, I will limit my time to addressing the difference between the draft document that has been passed along to you for final development and what Mr. Whidden, Mrs. Taylor, and Chairman Stanley voted in favor of on January 22nd. Please see attached copy of the agenda summary, item 7, and the January 22nd meeting's minutes of the business agenda, number 7. As that item was explained and acted on with a 3-to-1 vote that day, it was clear that the county attorney, the county manager, and 3 of the 4 commissioners were in absolute agreement that the county needs a rule or ordinance that would prohibit mines from being approved by special exception that would have the haul trucks accessing onto county roads. Please read the minutes and here's what it says. Just to make sure the crowd doesn't have it, but it's all very clear, as Mr. Pringle is reading, what y'all voted on, and in the final words, Mr. Whidden stated that he is not restricting any business in Glades County, but he is aware of the damage, destruction the big trucks cause to the county roads. He stated he is in favor of a moratorium on this issue to restrict usage and protect the county's roads. When this obvious disconnect was brought to the attention of P&Z Board on July 16th by Mr. McLaughlin, after resistance from Mr. Perry for Mr. McLaughlin attempting to read the January 22nd minutes, Mr. Perry stated that a mistake must have been made, as he had never been told or given direction that staff was to have merely generated a document that would prohibit mines from being approved that would access onto county roads. Though staff went off in a wrong direction, seemingly showing disregard for what the commission had voted on January 22nd, you can see by Mr. Pringle's notes included with the agenda backup for today's meeting that you, the board, still have an opportunity to produce an ordinance or moratorium that would accomplish what you were agreeing to in January. Please see and read Mr. Pringle's comments attached to and highlighted. And it's just a one-liner, so it won't take but a second or so. Mr. Pringle, can you read it? Or?
Yes, sir, it's on page 2 of my letter.
It says, please note, an alternative to requiring a performance security provision in the mining regulations as recommended by me and county staff is that the board could protect the county's roads and infrastructure by placing a moratorium on mining operations that use county roads for accessing to the mining property. Final note, it is interesting that when action was taken by the board in January of this year to prohibit dump trucks from mines accessing county roads, not one board member was aware that $184,000 of Glades County taxpayer dollars would soon be paid to a contractor to repair damage at County Road 74 clearly caused by trucks hauling dirt on that county road. Please develop and approve a good mining ordinance that prohibits mines from being approved at access onto county roads. Thank you.
Thank you. All right, any other comments? All right. I just want to make it clear one more time that right now Glades County does not have an ordinance on land, on mining, period. So that's why we're here today, to put in restrictions or whatever to make it so that when these applications come in, there's some kind of guidance to what they can do and what they can't do. So basically we're here today to look at this document and decide if there's something that needs to be added, taken out, or whatever. But, Mr. Pringle, I would ask you to kind of give us a overview.
Yes, sir, I will attempt to do so. First, this is a ordinance adoption public hearing process. There are 2 public hearings that will be held to consider, that will be held by the Board of County Commissioners to consider and make a decision on adopting a county ordinance. A county ordinance is a local law that is applied throughout the entire county. This is the first public hearing. It was properly noticed to be held today. All the prerequisite steps to this public hearing being held today have been satisfied. We did put notice in the paper. There was a planning and zoning board meeting because this is a land use ordinance. It has to be first reviewed by planning and zoning board. That step has occurred. You have heard comments today of the public and also 2 members of the planning and zoning board related to this ordinance. This ordinance is, as indicated way back and as referred to by Mr. McLaughlin, is an ordinance that has been prepared by county staff in response to what I believe may be the first application for a special exception for a mining operation that does not access onto a state road. And so that request, which was withdrawn subsequently and then refiled recently, that request for a comp plan amendment, a rezoning, and then a special exception approval for a mining operation was for a mining operation that would only have access onto a county road. That occurred back in January and triggered then the request to place a moratorium on applications, on the receipt and processing of applications for a special exception for mining operations in Glades County until an ordinance could be drafted to specifically related to mining operations. There have been a number of considerations, a number of discussions by county staff, a number of reviews of other ordinances in other county government, of ordinances controlling mining operations. There has been a substantial amount of work and effort that has been put into the drafting of a mining ordinance. The goal of that ordinance, the proposed ordinance, is to provide an opportunity for the county to specifically regulate and have established regulations and procedures for the approval of special exception applications for mining operations, and in particular to require specific items of mining operations where those mining operations might impact the county through impacts of the county's roads in particular and other infrastructure. You have other regulations in your subdivision regulations that have financial assurances provisions in them. I'm not saying they're the best written in the world, but they are there. And part of the financial assurances provision that is a part of the current version of the mining ordinance that is before you is a financial assurances provision that was written with the intention of tracking and having similar requirements for mining operation financial assurances that you require for subdivision applications for the development of infrastructure and for impacts on county infrastructure. So we tried to use that concept or that model that the county has related to subdivision regulations. At the throughout the draft ordinance that is before you today, what you will see when you read it is that there are specific requirements for an applicant for a special exception for a mining operation with regard to the initial submittals that will have to be presented to the county staff. At this time, you have nothing. And so at this time, a mining operation, either the landowner or the operator can make an application for a special exception, and that's it. There are no special requirements for any additional documentation or information to be submitted with the special exception application that would give county staff and then planning and zoning board an ability to fully understand the mining operation, the extent of the mining operation, or the impact of the mining operation on the county's infrastructure, including county roads. So the first part of the ordinance addresses and requires substantial additional information, primarily from the engineer of the landowner or the applicant, to be submitted to the county as a part of the special exception application process, so that a more thorough review can be made of the application by county staff. As you know, with a special exception application, the application comes in, county staff reviews that application, county staff makes recommendations for conditions or recommendations for denial of the special exception request. A special exception request is not for a use that is a matter of right under the zoning category. Rather, it is a use that might be proper if it is conditioned with certain conditions on the use. It can also be denied. That ability is not taken away by this ordinance. a request for a mining operation special exception can be denied based upon the facts and the circumstances related to that specific application. So that is still allowed. That has not been adjusted, taken away, modified at all. What has occurred is, in addition to the requirements and the description of all the application additional submittals for a mining operation that are contained in this ordinance, there are other specific requirements and regulations that are minimum requirements that in all cases must be satisfied and met. There's been a lot of talk about the specific item that was included before, which was removed, which relates to mining truck traffic not being allowed to go through school zones. The Planning and Zoning Board, in their authority and in their review, recommended, or it's my understanding, I wasn't there at the night meeting. By the way, somebody made a comment, I don't remember who it was, about the fact that I wasn't at a meeting and that it was a very important meeting and I shouldn't have missed it. I could have showed up, Mr. Chairman. I had a temperature of 102 degrees, and I could have come and infected everybody else, but I chose not to. I chose to stay home. And so, but if you want me to show up next time when I have a 102 degree temperature, you just tell me. I'll be here. I'll be here. Maybe in an ambulance, but I'll be here. I'll be glad to do that. But at the Planning and Zoning Board meeting, there was a substantial amount of discussion by the Planning and Zoning Board members. That's something that you have given them the direction to do, by the way, is to review land use and zoning ordinances and ordinances that affect your local county laws, your ordinances, your county code provisions related to land development in Glades County. So they did the job that you gave them to do. Now, they may not have done it the way that everybody wants. They may not have done it the way that particular individuals want. But they exercised the authority that you gave them to review the draft mining ordinance and provide you with their input. That occurred. Ms. Bashans was at that Planning and Zoning Board meeting. She took very detailed notes of all of the comments and recommendations made by the Planning and Zoning Board, and then incorporated their recommendations into the draft ordinance. That is the document that is before you today. Because this is a public hearing and because it is an ordinance of the county, the final decision making lies with the Board of County Commissioners. You four will decide first whether you want to have a mining ordinance at all, and second, what the contents of that mining ordinance will be. As you have heard me say on any number of occasions in the past, ordinances of the county that are adopted by the county can be modified by the county. They are living documents, I call them. I don't know where I heard that reference the first time. It was many years ago, but I've used it before with you. They're living documents. They're living laws. And so this board can adopt a mining ordinance, and this board later can modify, amend the mining ordinance as the board deems fit in the future, based upon changes in circumstances that may occur. Your staff has done the best that we could to create a set of regulations dealing with mining operations in the county to protect the county as much as we can. And the idea is you have the final decision making, and you're considering a lot of factors. What's in the best interest of the county as a whole? What's in the best interest of the county with regard to impacts on county infrastructure? What's in the best interest of balancing the interests, being fair and reasonable in balancing the interests between the county and the particular landowners who are affected by the ordinance? All of those are factors that you have to consider. You're the final decision maker. You tell us what's right, and that's what we'll write. And then at the second public hearing, we'll bring back the ordinance to you that you've asked us to prepare, and revise however you want it revised, and then we'll bring it to you. This is a big deal. It's a big ordinance. It affects a use in the county that can potentially have a substantial impact. Yes, I'm very aware of Crescent Road and the impact on Crescent Road, and trying to avoid a duplication of that happening again. You know, we finally reached the place where we said to that mining operator, we've given you opportunity to make corrections. They haven't occurred, and so we've ceased a special exception in that case and stopped that usage. That is still available under this ordinance as well. Through the Planning and Zoning Board is how currently the ordinance allows that cessation of a special exception to occur. The board may have different positions about that. The board may decide that you don't want that to occur, that you want it to be an immediate cessation, and then until correction occurs. I don't know. That's you. You decide that. We make recommendations and then we carry out what you want us to do. There's a great deal of information in this application, in this ordinance, that covers a number of topics. Everything from traffic in front of schools, to the usage of county roads, to financial assurances under your subdivision plat regulations. Actually, by the way, this was another comment that was made, is at a 125% of the actual opinion of probable cost. So there is an additional percentage of security that would be to cover the county's cost related to enforcement, by the way, of the requirements of the special exception conditions and the ordinance conditions. So we have a great deal of information in this ordinance. It is new, so this is the first time that you will have seen it and dealt with it. We've done the best we could to be fair and reasonable and to strike the balance between all the interests out there and to protect the county first and foremost. You can ask Mr. Singletary's attorney how adamant I have been in my conversations with her concerning protecting the county and especially the county's roads, and have said on a number of occasions to her right up until maybe yesterday or the day before, Friday before, that the county cannot afford adverse impacts on the county's roads by mining operations and financial assurances. I will not support any language, or I won't recommend to you that you adopt any version of the ordinance that does not require financial assurances and that does not enable the county to terminate a special exception that violates the ordinances that you will at some point adopt, hopefully, related to mining operations. So that's clear. I've said it before, I'll say it again, and now it's before you, Mr. Chairman. You've received public input. Ms. Bouchons is here. She attended the Planning and Zoning Board meeting in my absence. You've received the public input. It is now before the board to ask any questions, to give any direction, and to give us ultimately direction on how you want to proceed to the next public hearing for the final reading of the ordinance with any changes that you believe need to be made.
Sure, I got a litany of questions. I mean, this being county-wide ordinance, I mean, I'm looking at it pretty hard because this affects myself as well. The line starts up a mile and a half down the road from me. This has got to be pretty big. I understand, because a mine out here on 27 in Palmville is certainly going to be different than a mine 2 miles down the road from me if it were to happen. I'm not saying it is. I don't know of any, but it could. There's material down there. So where do we get into the nuts and bolts of just nailing this down. I understand because we've got several different mining situations that can happen around us. So is it through the special exception
Yes, sir.
to where we really can break down?
Yes.
School zone was brought up. I understand that. So in a special exception, maybe we don't allow mine traffic through drop-off times and unloading times. I don't have a problem with that. But that would be addressed, not in this, but this will be in the special exception.
Mr. Chairman, if I may respond, the ordinance is describing minimum guidelines for the applicant to submit information to the county, and then also minimum guidelines. As an example, the applicant has to describe the truck route that the mining trucks are going to use from the mining operation all the way to I think I wrote it to be the county line. I don't know if did that survive. I think it did survive. I can't remember, but all the way to the county line. So if that truck route, as an example, describes a truck route that goes past the school, then absolutely the Planning and Zoning Board, being the board that makes the decisions generally on special exceptions. I don't always have to. They could. Your ordinances actually allow them to roll it to the Board of County Commissioners for decision making to the county commissioners. But the Planning and Zoning Board would have the ability to say just what you said. No truck traffic between the drop-off times and the pickup times. Or the Planning and Zoning Board could say no truck traffic past the school. You're going to have to choose a different truck route. You'll have to go a different way. What this ordinance does not do as modified does not specifically in all cases prohibit truck traffic past a school pursuant to this ordinance language. It leaves it to the Planning and Zoning Board to make, or the Board of County Commissioners if you are making the decision on a special exception, to make that final facts determination based upon the facts of the particular case.
Okay, and the truck route is going to be defined. And I cannot remember the terminology, Mr. Dobbs, but the road has to meet the standard of the
Major collector.
major collector. That's, I've heard it 4 or 5 times and can't recall it. So who pays for that engineering, that testing to be done to make sure that that road meets the standard of the major collector?
The applicant, Mr. Chairman, by the way, I'll ask you every time before I answer a question, or I can just answer the question.
I've got a list. I've got a list.
Go to just answer them as he has. Okay, I don't have to ask for a specific, I will if you need me to. It is upon the applicant to provide us in their special exception application. That's one of the documents that they will have. Some of the information that their engineer will have to provide us is whether the road meets the major collector defined status. And if it doesn't, then the applicant will also, through their engineer, have to tell us what improvements will need to be made to the road to bring it to that level. And if I understood correctly, yes, so the applicant is required before any mining traffic occurs to bring the road up to that standard and then to maintain it at that standard.
I think that's pretty big to maintain that standard. What is this ordinance? What will that have an effect on existing mines? Is there none or the existing mines grandfathered in?
Yes. So the existing mines have special exception approvals, and the conditions of those special exception approvals control the use of that particular mine.
Okay, the policing of these mines. Okay, they've done their engineering. They brought the road up to standards of the collector road. Okay, so truck traffic occurs, they feed a hole into the road. Who polices that? Is that going to be planning and zoning? Is that going to be some other entity? How does that work?
Typically, that is a code enforcement item in with this ordinance. And so you have some options. Normally, that would be a code enforcement action, and code enforcement would bring an action a code enforcement case would be filed.
Right.
That's one option. If it is a type of detriment that creates a public nuisance, then it could also go back to the Planning and Zoning Board under a public nuisance methodology. I think there are some other provisions in here, and this is so long until I have to go back and read it. Ms. Susan may have some other comments about that, but those were the two methods that I remember. There was, I think, some language at one point that said that and I think it may have even said that the community development director could even terminate the special exception approval. I think I also may have used the word immediately if maintenance was not occurring. I think some of that may have been modified a little bit in this final version that you have in front of you, so that now it needs to go to the Planning and Zoning Board for a decision to be made as to whether the special exception should be terminated.
I really don't want it before code. I'd rather this go directly to Mr. Shannon, and I'd just rather not deal with code. I've had that experience. And also, if the conditions aren't met, and the problem I have with code is it's such a long time to get any result. And I get it, things don't happen overnight in government, but I want us to have the ability, if these conditions are not met or maintain the road at a certain standard, we have the ability to shut the operation down immediately until these corrections are made. This kind of shows our hand. We don't have to wait for a long, drawn-out court date. Maybe this is in the special exception part of it, if we give ourselves that power.
Well, in a previous special exception that was approved, that if the applicant was not in compliance or violated any of the conditions that were in that final order, their special exception use was to cease. If they want to use that use again, they have to go back with the special exception application.
Okay.
They don't automatically get to, at least in that one case.
So if I'm not maintaining my roadway, I'm called out on it, residents are angry, I don't just lose my ability to mine at that time. I have to reapply for a whole another permit, go through all of this again.
So, Mr. Chairman, if I may?
We're getting that now.
I'm sorry. Have it. The current version of the ordinance, however, doesn't say that in particular. The current version of the ordinance says the violation of a condition, limitation, or requirement of a mining special exception approval or of a mining permit will, in addition to any other legal remedies such as a code enforcement action that are available to the county, authorize the county to revoke the mining special exception through the Planning and Zoning Board or through a nuisance abatement process. That's different than the current mechanism. The current mechanism is that if a condition of a special exception is violated, and it's a substantial violation. I mean, this is not the trigger normally that community development would pull because a blade of grass is 3/4 of an inch too long.
Right.
But if there are substantial damages that are occurring to county infrastructure currently, and that's a violation of a condition of a special exception, or which includes the violation of any county regulations generally, then the community development director has the ability now to say, you're in violation, here's the condition you're in violation of, we've told you, we've given you a reasonable opportunity to correct the violation, you haven't done so, your special exception is hereby terminated and ceased, effective now. That's the norm that has been in effect in the past. This language, as revised, is a different mechanism and provides in the county to go back to the Planning and Zoning Board for a decision to terminate the special exception. I believe I wasn't at the Planning and Zoning Board meeting when this change occurred, but it's my understanding that change was proposed and included because if the Planning and Zoning Board created or approved the special exception in the first place, then the idea was the Planning and Zoning Board should be the public body that terminates the special exception if
I agree with
there's a
that.
violation of the condition. The problem is the delay in time in getting that done, and getting all the way through those steps. And if there's really a problem, then I guess we would just have to call a special, Planning and Zoning Board.
Yeah.
If these regulations stay intact, we would have to call a special Planning and Zoning Board public hearing to consider the revocation of the special exception.
Okay, and then just last one so far. I'm in violation. I'm beating up the road. It's clear that I'm beating up the road. Mr. Sanchez pulls my special exception. Well, I don't care what she says. I'm keeping mine anyway. I'm making my money. Who enforces that? Okay, who's going to enforce that stopping of work?
Normally, the Planning and Zoning Board, sitting as the nuisance abatement board, makes a decision. We have, and we've done this before, where we would have a public hearing that is actually a due process type of a hearing. We would present evidence, the county staff would present evidence, and the landowner would have an opportunity to also present evidence, and then the Planning and Zoning Board as the nuisance abatement board. Because remember, your Planning and Zoning Board wears a number of different hats.
Right.
In this case, they would be wearing the hat of the nuisance abatement board, and the nuisance abatement board would make a decision as to whether whether there is a violation of the county code of laws and statutes, and if so, what should happen. The nuisance abatement board does have authority to fine, and ultimately does have authority to correct violations. That's, I think, going to your question. If the nuisance abatement board said there is a violation, there's damage, the damage has to be corrected, the nuisance abatement board could say to the landowner, you are obligated to make the correction and you got 5 days to do it. If you don't do it, we're going to come in and do it, and we're going to charge you for the cost of us making the repairs that you should have. That's how that works. So ultimately, the county will have the ability to make the repairs, to fix roads if damage occurs, and that's part of the reason that I think the financial assurances provision is so important, is the county would then look to that financial assurance, whatever the bond is or whatever's been put up, to recover the county's cost for the maintenance work that the county has to perform if the property owner refuses to do so.
Okay, so just hypothetical, Mr. Shant shuts me down because I've not maintained my road.
Planning and zoning shuts you down.
Right, right.
So do this ordinance the way it's currently.
Okay, yeah. So, I continue to haul. I mean, I guess she doesn't, or planning and zoning is not gonna pull my permit. They're gonna give me a chance to fix my road. I continue to just ignore the shutdown. She has the right to pull my special exemption altogether. And just,
If the nuisance abatement board says to terminate the special exception, then yes, sir.
so if I'm found egregious and just ignoring policy, she can shut, or planning and zoning can shut me down.
Nuisance abatement board, yes.
Another thing a lady brought up is distance between mines. I'd heard her say it one time before, and I got it kind of out of my mind, forgot about it. I think that's important to look at. I've never put a lot of thought into it, and I put none in it until she said so. I wouldn't have a problem putting mine down the road for me, but if I'm surrounded by mines and all corners of my property is nothing but sand mines, that's a little extreme. Have we looked at that? And I don't know that 10 miles is the answer, but there's got to be a distance, and I really don't know what that would be, but have we looked into that as far as, I can understand the idea, you know, I might deal with a mine down the road from me, but if I'm just surrounded by it, that might be an issue.
Yes, sir.
Or that would be an issue.
And the planning and zoning board, unless they roll it to the Florida County Commission for decision, would hear staff's recommendations on whether to allow another mining operation based upon all the circumstances, including how many other mining operations are in the immediate vicinity. Again, it is not an allowed use as a matter of right in any zoning category. And in fact, it is only allowed as a special exception in just a few limited categories. Ag, industrial, is it allowed in industrial or just?
I can look it up on my phone.
But it's very limited. The bottom line is, you can't just do it anywhere.
Right.
It's not allowed in residential zone properties.
It doesn't have any permitted use right, or any right that it's not, if you have the correct zoning district, say you're ag, open ag, and you wanna do a mining, it's not a permitted use, it's only special exception. It's the only way a mining operation can come into the county.
So we're going to control me being surrounded by mines just through a special exception. If I've got one on either side of me and I obviously don't want another, we're just not going to grant that special exception.
That would be a condition that the planning and zoning board could make, who in that case would be the Board of Adjustment. So yes, that's one of their other hats that they wear.
Right.
And when Mr. Pringle was talking about, as far as conditions, if somebody's not following their approved special exception, and it going in front of the planning, going in front of the board, the nuisance abatement board or the Board of County Commissioners, that wasn't in the first draft. That came in based upon our meeting that we had in June with the Planning and Zoning Board / Board of Adjustment. And that goes to show that we've been working closely with the Board of Adjustment and any of the recommendations and things that we had find that we would make further revisions. As you know, that's what happens with an ordinance. Is each time you work on it, there might be some changes, either additions or deletions.
No, I see the work that planning and zoning do yourself, Mr. Frank's put in, and I appreciate it. It's a lot because you guys started out with nothing and have come up with this. Can we make it better? Maybe, but.
So this gives a baseline for
Yes,
the Board of
yes,
Adjustment to work from, and then they could attach any conditions that they felt were necessary based upon the application, where it's located, things like that.
Right.
The specific facts related to the request would also then be considered for additional conditions. This describes minimum requirements that apply to everyone, and then additional conditions can be attached on a case-by-case basis based upon the facts related to the case, including facts such as there's 20 mining operations within a 1 mile stretch. We don't need the 21st.
Right.
Could be part of the recommendation. Here's, by the way, mining operations and operations can only occur in the open use floodplain district, open use agricultural district, light industrial district, and heavy industrial district. That's the only 4 land use zoning categories where a mining operation can occur, as a special exception.
That's all the questions I have so far, and you guys got to excuse me for a minute.
I'll go,
If I may, Chair, can I, just for the record, say that this has been properly noticed and advertised? I know that was mentioned by the county attorney, but I want to make sure that, again, that's in there. And if I may, can I read the ordinance caption into the record? Glades County, Florida, ordinance number 2024 to be determined. An ordinance of the Board of County Commissioners of Glades County, Florida, amending the Glades County Code of Ordinances, Part 2, Land Development, Chapter 125, Land Development Regulations, by amending Article 5, Supplemental Regulations, Division 3, Special Exception Use Regulations, by adding a new section, 125-329, Mining, Mineral Extraction and Processing, providing for incorporation of recitals, providing for codification, providing for scrivener's error, providing for conflict, providing for liberal construction, providing for severability, and providing for an effective date.
Well, I want to commend the planning and zoning for everything they've done and your staff, everybody's staff, but I appreciate planning and zoning, and I'm not trying to do this as a knockdown or anything, but lighting is a very, very special application that's coming in, and it's very controversial to the neighborhoods that are there. And I know right now special exceptions don't go to the county commission board, but I think that this ordinance should say that anything, the final chapter should come to this board of county commissioners for final approval. Even though it'll still go through planning and zoning, they'll make their recommendations, but I want this board to be able to come in and if we want to change the route, we want to do something different, that we have that opportunity to change anything that's there, because the planning and zoning is an appointed board. We're elected. We're the ones that take all the heat. And I really don't want this pressure on me, but I think it's only fair to the citizens that it comes to the people they elect to make the final decision. And that way, and I want it clearly written that we have that opportunity to change anything that we deem that the citizens feel they're not correct in the ordinance. Because there's going to be, you can buy, it's just like, I know you guys are pushing down on county roads. Well, we got county roads that there's not even a house on, that are dirt roads. And so if we make a line that's, say in this ordinance saying, well, no county roads, well, you're cutting out, I'd say 85% of the county that's on dirt roads and stuff that a mining operation really wouldn't affect. But I do see we're in different neighborhoods where, so when a special exception comes to planning and zoning, they're going to be anchored by this ordinance. And that's what they're going to say, okay, you pass everything in this ordinance, you have a say-so to go ahead and do it, because that's all the planning and zoning is going to have, is this ordinance. And if he meets all those standards, or whoever's applying and meets all those standards, then they have to give them the special exception, because that's what the ordinance says. But I want the board to have the opportunity to come back in the end and say, no, this is in a different area, it's a whole different circumstance, and it is going to be a different circumstance with where you live and where this thing goes in the county. Because it's just like detrimental. How do you so it's a detrimental to the community. How do you put detrimental in an ordinance that says, oh, is it only detrimental to one house, or is it detrimental to 100 houses, or how is that? So I think that the load should be on this board to make the final decision. So that's my biggest input. And the other thing is, so if they come in and they say, we're going to go this route, and the road study says, well, all these roads have to be widened and put a shoulder on each one of them. So that would be part of the special exception that they would have to improve all those roads to that capacity.
That would be one of the conditions, yes, sir.
Because school zones, I think that's ridiculous to have trucks going through school zones, especially when they're not there already. But that's why I think there should be a line in here that says the commission has final say. The commission should have anything that happens with that line, even if there's a complaint filed about it, the commission should have the final say so when it comes to that point. I won't accept this unless that's in there. So.
Mr. Chairman, if I may. So then the language that I just referred to, read a minute ago, that said that the planning, that if there is a violation, it would go to the planning and zoning board for decision making. You want that to be also changed to say that it would come to the Board of County Commissioners?
You can still go through planning and zoning, but I want this Board of Commissioners to have the final say so.
I think that's better. That's more eyes on it. The planning and zoning looks at it, passes it to us, and the commissioners, and they make the final vote.
The only other thought that comes to my mind is the timing of the completion of that process. If there is damage that has occurred, if there's an impact that's substantial adverse impact to a community that is occurring as a result of a violation of a condition of a special exception, then if we have a planning and zoning board hearing and review, and then have a second, and they're all public hearings, so they have to be noticed, and then there's a second public hearing in front of the Board of County Commissioners for its final decision, we're talking at an absolute minimum, I would see, yes, sir, at an absolute minimum. And that's if we have special public hearings and you know, don't try to schedule things on your normal dates, meeting dates. If we try to do something on your normal meeting dates, it might be 6 weeks or more.
Now you're talking about for a violation?
If there's going to be, I read the language a minute ago, maybe I can find it. If there's going to be a termination. So what I read to you a minute ago says, well, I'm going to read a little extra. The county shall attach any condition, limitation, requirement, or special authorization to a mining special exception that is appropriate in the county's sole discretion to protect the best interest of the county, its residents, and landowners, including adjacent landowners, from adverse impacts of the proposed mining activities and to effectuate the purposes and to carry out the spirit of this code. Period. Such conditions, which may include regulations either in addition to or more restrictive than those otherwise set forth in this code, shall be set forth in the mining special exception approval issued by the Community Development Department. That's after the Planning and Zoning Board makes its recommendation. Then it says the violation of, this is the language I read to you before, the violation of a condition, limitation, or requirement of a mining special exception approval or of a mining permit will, in addition to any other legal remedies such as code enforcement action that are available to the county, authorize the county to revoke the mining special exception through, currently it says, the Planning and Zoning Board or through a nuisance abatement process. Are you saying you want that to be through the Board of County Commissioners? And if so, do you also want it to go in front of the Planning and Zoning Board first? I'm saying that will add time to the review process if you go through both steps.
I think there should be somebody that's able to say, one person should be able to say, you're in violation, I want you to call operations immediately. And then I think it should go to both boards, planning and zoning, and us to decide whether they are in violation or not.
So a temporary cessation to be approved by Community Development Director.
Somebody, or the county attorney, he can shut them down.
Well, don't give me that authority. It'll stop every time.
But we don't need to wait 3 months to tell them they're in violation. We need somebody or the county manager, somebody just to say, hey, you're in violation, you're being told to stop all operations until it goes through the process of again as well.
Okay. To this point, the Community Development Director has made that decision based upon, and she always talks to me, she talks to the county manager about these kind of decisions. She doesn't just do that in a vacuum. But because the Community Development Director is the office that issues the mining permit and ultimately signs off on the special exception and all the conditions and everything else that were approved by the Planning and Zoning Board. In the past, the Community Development Director's position has been the one that makes that decision. If it's the board's desire to have that made by the county manager, then that's fine too. I just need to know how to write the ordinance, that's all.
I'm good with community development, as opposed to this.
Okay, so under your proposal, the Community Development Director would have the authority to temporarily cease an operation, a mining operation, until it can go in front of first the Planning and Zoning Board, who would make a recommendation, and then the Board of County Commissioners for final decision on whether there was a violation, number one, and number two, whether that violation should result in the termination of the special exception. Is that the process that you're just thinking about?
Sounds good to me.
Am I close to describing it? Okay. Is that what you want?
That's my personal thing.
Okay.
I think it should come before us, absolutely, because there's times whenever someone called me and say, this has been approved by special exception, and we had no idea. So it should come to us, but don't make it such, Mr. Pringle, you keep adding to and talking there, be careful. We wanted it right, absolutely, but it's got to come before us in the end, I believe.
I agree with that.
So, and then the only other thing is that, we have 2 public hearings scheduled. And I just heard a lot here today that I haven't had the time to digest yet, but, so you're gonna bring me back a document next week, and if I read something in here that I thought should have been included, can we have another 3rd public hearing or not?
Well, the board can decide that you want to have a 3rd public hearing, yes, sir.
I mean, it may not, but I'm just trying to do, because we're hearing a lot here today, and you're telling me I gotta tell you in the next 10 minutes how I want this written.
So to keep in mind, the moratorium goes through the end of August, I believe it is. So if you wanted to have a 3rd meeting, that moratorium would
That's
need to be extended. And then we also have to advertise, which adds another 2.5 weeks, I believe.
Yes. You're, practically speaking, you're looking at getting this done in the month of September sometime, versus what is currently scheduled, which is a 2nd public hearing to occur at your night meeting in August, because the moratorium that was put into place expires. It's been extended to the end of August, but then it will
I think the
expire.
22nd. I don't have those minutes over here, but if you want to have a 3rd meeting and it's past your hearing that we have, the 2nd hearing we have scheduled, we'll have to extend the moratorium and advertise.
Could we
Which
do
you
that
can
at
do.
the night meeting if we had to?
Yes, sir, you can do that.
But I might be fine with it, but I just want that option.
Well, so far, based on everything that everybody has said at the board level, we're making one change on page 11 of 14 of the ordinance under the conditions provision to describe this different process for ceasing on a temporary basis a special exception use where there's been violation that has occurred of a condition, so that it eventually comes back to the Board of County Commissioners for final determination on whether the special exception should be rescinded completely. So that's the only language.
Well,
I've answered questions,
and the
but I
fact
haven't had any revision to any other language that I've found.
And the fact that I want the board to have final approval and
Yes,
able to make any further restrictions or whatever.
yes, which is already in the document. But yes, you want to have all special exceptions for mining to be approved by the Board of County Commissioners after review by the Planning and Zoning, with reservation specifically stated that the BOCC is not bound by the recommendations of Planning and Zoning, so that the final decision is made by the BOCC and the BOCC's authority. That's one. And the second change is to revise the language on the violation of the conditions to say the Community Development Director can temporarily suspend operations of a mining operation where there's a violation until the matter can be brought to P&Z and then ultimately to the Board of County Commissioners for a decision on whether the special exception should be rescinded.
If you go to page 414, Mr. Pringle, on the express egress, and that was the part where the language is added that they have to, the property has to be accessed from a roadway that meets FDOT stability factor for a major collector. And if it doesn't, the property owner has to bring that road up to FDOT stability factors until it intersects with an FDOT road. We might want to also add to that, and maintenance, is that the section probably discussed about, to make sure maintenance was included on these roadways?
I heard that at the planning and zoning meeting. It was not just to get the road to that standard, but to maintain that road.
And
I think that was good language.
Okay. Yes, so we could add, that would be a simple change to add, shall improve and continually maintain throughout the mining operation. So page 414, Ms. Bouchon's, we're also going to have a change there based on what Commissioner Stanley requested related to the process going to the BOCC instead of the planning.
Good news.
Okay.
Well, Commissioner Wiggum addressed most of my concerns, especially the one being with the school. But I do believe something can be figured out through a special exception with that we have options. Also, just to address the lady's concern on the hours of operation. This ordinance does provide that the hours of operation are daylight hours, Monday through Saturday. And her other concern was about paying for the roads. Well, we've discussed that. So financial assurance is also provided for in this ordinance. So this ordinance is countywide, and I appreciate the planning and zoning for spending so many hours working on this to make it good for Glades County, all of Glades County. And I know there were concerns that were addressed here, and believe me, this board understands those. But we need an ordinance, and I think this is a good start. So, thank you. And we can address things through special exceptions. But this is looking good to me. I appreciate your work on it.
100%, we need the ordinance. Without the ordinance, we're the Wild West. Anything goes. I think we've experienced some of that. So, you know, whether you agree with mining operation or don't, you have to agree that we need an ordinance. I mean, this keeps us from just being the Wild West. We've seen the repercussions of that. So, if we don't like it, we got to change it to something we do like. It's pretty solid, I think, other than a few changes we're looking to make.
So, any discussion?
Well, I'm in total agreement. We've absolutely got to get this in effect. There's just so many areas that I hadn't realized until everybody starts talking about it. Ms. Bouchon and Mr. Pringle bring stuff up. And I read the first copy. I had it, I read it twice. And then we come in and get this one, and the changes have been made. Like I said, I'm all for this. We've got to have it. I just don't know if I'm ready to vote on it until I read this and compare everything. And there's so many areas in the mining business that we can be taken advantage of if we have nothing. And this way we do have a little bit of options to do some control to them. But I'm looking at if we don't approve this, and don't take this wrong. Now I'm telling y'all, don't take this wrong. But there's no chance that the mine is approved out there. The first thing that's going to happen is R&R is going to jump on us. You watch. So those are things I've been thinking about. So we need to do this to have some teeth in the county with have control.
Right, and I think this ordinance will help us. I know they had some concerns on the way from Cape Coral. This will help us not to get to that point, having these ordinances and these guidelines and special exceptions.
I was talking to a gentleman yesterday, and just right out of the blue, another area was brought up. He brought up, and something I've never heard. None of us have heard about this at all. So the possibilities of these things popping up is real. So that's why we have to have this control.
Mr. Pringle, I know that in here it says that it's surety bond will have to be for the roads and stuff, but can we still put like a tipping fee on here too?
Yes, sir, you can. There's not a tipping fee in the ordinance that's currently written. But yes, you can require it.
Any further questions? Any further public comment?
Yes.
Come up to the podium.
Understanding the process for a public hearing, generally we get to talk after a motion was made and have to be sworn in, am I correct?
Oh, Mr. Pringle, no.
The question I have, and I appreciate you asking, is there any further comments, because I see some questions asked, and you're making notes over here, you're gonna make some changes, but have you considered any of the recommendations that I made, 1 through 8?
You laid them to them.
That's why I told him that we decide, like I said, I've been presented with a lot of stuff here today, I can't make a decision in 5 minutes.
And that may be my misunderstanding.
That's why I said it next week, if I say that I've read something in here, I got something from this meeting that I wanna make changes, then we'll extend it to the third public hearing.
And there again, that could be my misunderstanding, but I thought you had an opportunity, as you did with 1 or 2 or 3 or 4 things, to go ahead and act on them today. And then the ordinance that you see on the 26th will be a near final version. So I would ask that some of these be considered today, maybe introduced into the ordinance as it's in development. Otherwise, you're gonna be sitting here on the last Monday night, or the 4th Monday night of the month, trying to introduce them and talking about another meeting. And so I encourage you to consider these. They're good ideas for the ordinance.
Well, like I say, we talked about the 10-mile zone, we don't know what.
Well, the one in particular is the financial, because we all know that you can't hardly collect money from a surety. And so I was saying, if you have to go out and spend $15,000 with attorney fees to get a surety to do the right thing, then the mining property owner or the operator ought to pay those. If the surety pays you $6 million and you needed $8 million to do the road repairs, you need to collect that $2 million that the surety didn't pay from the property owner or the mining operator. Property owner is where you're going to be. This is just to protect the county. Do with it as you choose. Thank you.
Well, the survey is in the thing, so I don't know what you're asking us to do.
When the surety doesn't perform, we want the property owner to have the financial responsibility for picking up the difference.
And
Can we add that?
I can add specific language to
Please.
say that, but it's already, yes, sir, it's already a part of the ordinance if any property owner, like with the code enforcement action process as well, if a property owner is in violation and they have caused damage, then they are responsible for that repair. The financial assurance is in addition to that obligation. The property owner has the obligation regardless, and then the financial assurance provision that I put in is a second layer of protection for the county. So if that property owner does not do their responsibility, carry out their responsibility, then you have the financial assurances available at, I think our other ordinance, and I'll go back and make sure this one also says it, at 125% is what I remember is the number, so that there is that difference to also cover, and I've also written it before, where out of that 125% financial assurance number, the county is authorized to use to reimburse the county for the county's costs.
But you could have a 150% number, 175% number.
And the
If you
property
don't
owner is
collect, if you
responsible.
don't collect from the surety, you need to be able to collect from the property owner.
And that's present, yes, sir.
Very good, thank you.
But I can add that additional language for clarification, Mr. Chairman, if you want.
Hey there. I'm back up because I really want you to consider, all of you, adding a minimum of 10 miles between mines on the ordinance. Otherwise, you're gonna be up here all the time. Planning and zoning is gonna be up here all the time. And you're gonna end up with, which was what our big concern is, 5 guys operating 5 places within, a 10-mile radius. 10 miles between mines, just give it in the ordinance, put it in there as a starting point. It looks like you're gonna push everything to special exception, and it's gonna get reviewed and then come back to you at some point anyway. But I mean, if not, this is just gonna be continual. From Miami and in Orlando, and we faced it in both places, and it was just out of control.
I want to add 10 miles, it stops.
Like I said before, I'm extremely opposed to 10 miles. I don't think there's any basis for it. Right now, I was just looking up, there's 800 square miles in Glades County. You're talking about 8 miles total forever, not including the ones that are already there. And if that includes the ones that are there, now you're talking 7, 6, 5. The other point that I made was in Okeechobee County, right across the Kissimmee River, you've got about 7 mines within a 1-mile radius that all got shell out of it. So you're going to have one landowner who's got shell under his land. You're going to have another adjacent landowner who's going to have shell under his, and he's not going to be able to mine his when the county needs it. And it's going to put the Glades County at a disadvantage for not having the materials that we need to run the county. So again, I understand the concerns about 10 miles. I understand the concerns about having one after the other. But if the material's there, they need to be able to mine it. And if you put 10 miles in there, again, I think we have correct me if I'm wrong, Mr. Prangle, but we have the ability to say, we don't want one this close, and turn them down. And if we say, oh, okay, it's fine, y'all will have the ability to say, no, we don't want you to. So, I mean, like I said, I don't know what the basis is for the 10 miles. I don't think anybody has given us a basis for the 10 miles. What is it's something I think somebody grabbed out of the air. So I don't think there's any. So anyway, that's mine. Just wanted to. That one just gives me heartburn because I've worked on too many mines in my life, and I've and all this kind of stuff. And I just understand how the material works. The sand in Glades County, you can probably get it just about anywhere. Shell is a whole different story. And like I say, this is over the whole county, and it covers everything. So you're not just concerned about the sand, which you may be able to get in a whole lot of places. The shell you may not be able to. So I don't want to tie our hands behind our back unnecessarily.
Yeah.
Just state your name and address for the record.
Sarah Jewell, Silver Lake Road. To that gentleman's point, we are talking ultimately as an example of Muse. We don't want a mine less than 10 miles between property. Our lots, as it is, are around 5-acre lots. So I ask you guys to consider, yes, we definitely need the ordinance. We need to have parameters. But ultimately, it's going to go down to the Muse mine. And you need to consider the residents. This is who you are taking care of. We voted you in. We're going to vote you in again. But we need to have representation in our government that is precluding what everybody thinks is so terrifically important, and that is money. That's the end of my story.
You want to speak?
Yeah, I think that.
You got to come up to the podium.
Oh, I'm sorry. As I said before, you're going to decide in a special, for each mine it's going to be a special thing. But you've got to make something that's broad enough that you're not up here every week talking about it or getting another application. And so this is our concern. And I think that, this isn't, there's a lot of land out here and it's the Wild West, but you now have to consider residents, the taxpayers who come here, and the schools, and whether we get not so much shell rock or a little less sand, because you now have hundreds of residents, or you have new developments going in. I don't think we need seven mines within 7 miles in Okeechobee. Go look at that and then go look at Muse. I mean, you know, we're trying to do a nice development. Everybody takes care of their property. We're invested in seeing the county grow, and we're invested in seeing new development come. And the last thing we want to do is have somebody not come because we look like an industrial mining zone. So make it easier on yourselves, make it easier on our limited staff, and don't find yourself up here every 2 weeks for another meeting. Thank you.
Mr. Chairman,
Yes, sir.
I have a very brief thought. Number two, I have 2 brief thoughts. Number one, as I mentioned earlier, a mining operation is not allowed in residentially zoned property, and a large part of Muse is residentially zoned, so that a mining operation would not be allowed in that area. So that's point number one. That is some additional protection that just came to mind. The second thing is, this is a countywide ordinance of countywide application. If it is the Board of County Commissioners' desire, based upon evidence, based upon facts, the board could say that in a particular area, mining operations will be separated, or you'll only have a certain number allowed to be separated by distance for one part of the county or for another part of the county, based upon facts, based upon evidence. So you have that ability to do that in the future as well. If there was a part of the county that needed additional protection, versus placing that provision in a countywide, in an ordinance of countywide application, where those facts might not always apply. As you know, Likes Brothers owns, 70+% of the county. And so there are large parts of Likes where they could have mines close together, and it would not affect anybody except they would have it. But in the area of Muse, maybe the Board of County Commissioners wants to say there are limitations on the number of mines in that area, based upon evidence, not just speculation, but evidence. You could have your engineers look at that if you desire to consider that.
I would agree with you as far as, because, I mean, look out there on 78 where Ortona, you got all the sand mines there, you know they're gonna keep expanding down that road. So if I say you can't be in 10 miles, so then they're just gonna be 10 miles down the road and start another one, then every 10 miles down the road, I'll have another one, where even on the north end of the county, there's so much open land off of State Road 70 out there that if somebody wanted to go in there and started mining sand, because there's nothing else, I mean, there's just cows out there, there might be 1 or 2 houses, but we can't say 10 miles, because I would rather them all be grouped in one cluster than just spread them all over the county and then just cause more stuff all over the place. So I agree that if there's a way that we can say, hey, Muse, we only want them every 10 miles in use, then that would be, but I don't think I want to restrict the whole county to that level. That's my opinion.
And that is, Mr. Chairman, an action the board can take at any time in the future, again, based upon sound engineering and a review of the facts.
Any other public comment? Yes, sir, come on.
Go ahead, Lisa.
Just state your name and address for the record.
My name is Alex Grant, and I live at 1248 Sunset My comment very simply is there's a lot of talk, legal ease going on here and speculation about if and maybe. But one thing that I've learned in my life, the one thing I've learned in my life is if it's not in black and white, it's not so. We've had people stand up here and say, you need to put this in there so that it says there, okay? That's like the surety bond and making sure that the cost is recovered by the county. And I don't think there should be a place where the county has to come in and spend money that they don't have, like they just did out there on 74, and hope that it can be recovered at some time. If you can't enforce the guy and make him make the repairs, then you can't make him pay you. And I don't care. You can go to the small claims court, get a judgment, and you won't never get your money. My church has been beat out of $3,000 the same way. I got the judgment, but I didn't get a recovery. It needs to be spelled out in black and white, not maybe.
Thanks, sir.
Thank you.
Did you want to speak?
Is there anything written in, I mean, that we can just jump this in, hopefully not ever have to worry about it again, just take this mining out of school zones completely? Is that against the law? I mean, because that's going to be a big concern, you guys, when there's an accident out there. And everybody, we've talked about it over and over again, but I don't see where it's in this ordinance.
It's not in this ordinance because right now Highway 27 is in a school zone and there's semis go past there every day. So if I enact an ordinance that says that semis can't go in a school zone, I have to reroute 27 out here. So,
But you have to remember that there are DOT, there are signs, there are infrastructure, there are shoulders, there are red lights, there are a lot of things that have been in place there to help slow all that traffic down.
I'm telling you that in this ordinance, it's giving us the final decision and telling them which route they have to go.
There's not but one route,
So,
right in front of that school.
and by putting the board as the final decision is going to give you the voice that you need. That's what I'm trying to explain to you. I can't.
We're looking at you guys to help us.
I
And
don't know if we can legally say school zones or not.
Maybe school zones in certain areas?
I think it needs to be addressed. And I don't really want to point any fingers, but I feel almost like this ordinance, it's almost like the fox in the hen house. To have them help us write an ordinance, our ordinance, to help control our, I'll say it again, look it up, our quiet enjoyment. We're about to lose it in Muse, and maybe a 10-mile thing is something we need to discuss. Maybe it needs to be more, I don't know. I know that mines are very invasive. And I just hope you guys can see what we're going to be looking at in the future.
I'm with Yvonne. If you can't say school zones, why can't you say residential areas? Or residential, whatever. This is for the future of the county. It's detrimental, it's huge. You're going to have more school zones and communities coming up in the future, whether they're on a county road or a state road. You still don't want that kind of traffic going through the school zones. So why can't you find verbiage to say residential, because school zones are in residential areas? Is it possible?
asking you a question.
Exactly.
You did answer.
Okay.
Yeah.
I gotta have. Previously, the ordinance had language that said access and truck routes to and from the site are prohibited through school zones. That was language that was there, but in reviewing that language at the Planning and Zoning Board, it was my understanding that the Planning and Zoning Board said that was overly broad to be applied on a county-wide basis in all cases. I mean,
Is the fact that there was already, mine
No.
trucks go through a school zone already here in the county.
So if the question is, can the language be there, Ms. Sanfrani? The answer is yes, it can be there. And it's up ultimately to the board's discretion to decide. The Planning and Zoning Board has recommended the removal of that language based upon the public hearing that was held before the Planning and Zoning Board.
So today, these recommendations are coming to you for revise for the next meeting. So can we have that put in? Would you all want to put some kind of verbiage in there about the schools and residents to help keeping it away from children? Because the day a child gets hurt, that's the day you're going to end up resenting anything that you did here today if you don't put something in there about schools. So that's all I have to say. I hope, Mr. Pringle, you get the direction to put something in there.
I do have just one more comment, real quick. The school in Moorhaven is not directly located on US Highway 27. There is another road a block off that school fronts on. It is not like West Glades, where West Glades sits right up on the road. Thank you. Good morning, Susan Stevens again. To the point on school zones and trucks through school zones, Ms. Taylor made an excellent point that the special exception process allows the conditioning that would include hours at which trucks can go. If the truck route, if there's no other way except through a school zone, then you can prohibit the trucks from going during school hours, such that you would not have a conflict between the trucks on the road and the school traffic. That is something that you have the authority to do, to condition it in your discretion to be protective of the citizens based on the specific circumstances surrounding the mine issue, the road it is on, where it is going. It is already prohibited through active subdivisions. That is already a prohibition. So that residential conflict will not exist. And that would be future residential active subdivision as well. So that already exists. As you said, there are schools out there now that have farm traffic, they have truck traffic past them, and this would allow you the opportunity to restrict when the trucks go by there, and you would have that opportunity 100%. And we fully support this coming to the Board of County Commissioners for final approval, fully support being able to shut down bad actors immediately. We think that is important for the county.
The school thing gets me because it's really, really important. Someone had mentioned that the distance of the school, I guess in Moorhaven on 27th, is quite a distance from that road. Whereas this distance, West Glades is right there. That to me is something that should be factored in. The distance of the school to the road, I think, is important because you've got ingress and whatever, in and out all the time. It's it could create some problems, big problems. The other thing is the time frame. That's one thing, limiting when the trucks are going to be there. That would be good, except that in this mining operation, some mining operations are 24/7. So you've got a lot of hours those trucks are going to go by there. And who's to say that the buses can come in and there's been damage to those roads? They come in, there's a pothole that wasn't there the day before. they hit the pothole and there's damn kids are hurt or something happens or anything could happen. So there's, I just am totally against them going past these school zones. There's a lot of places they can go. Leave the school zones alone. Build another road. There's truck access only to the road they're trying to get to. There's gotta be another way. We can make it better. Just because it wasn't done before, everybody here can write something that's a state-of-the-art document that other people start following because we did. Thank you.
Y'all got caught a bit. My name is Paul Beck. I live at 1599 Alligator Road, Moorhaven. Actually, at Lakeport, I've got a mining operation right behind my house, and their driveway where they come out is about 200 feet from my house. Other than the dust, I don't have a whole lot of problem with it, except when they hit the jet brakes. But kind of seems here that everybody's kind of got the same opinion. You want to protect all the kids at school, and in reality, there's an extremely simple solution to all this. Everybody can get what they want. You can get the heat off of you, and everybody's happy. There's a drainage swell on both sides of that road. You put a culvert from one side to the other, and you put a weight restriction on that culvert that'll handle the school bus full of kids. Trucks cannot use it. You got other people want to pass in the school zone, put a speed bump there. It's not gonna happen but one time. I think you're a little bit ahead on the presentation here. And, if it drags out a little bit longer, you got to extend your moratorium, whatever. Send it back to P&Z with all your notes here and see what they come up with, and then move on from there. That's all I got to say.
Thanks, sir.
Thank you. Richard Sobel, 5330 Silver Lake Road. There's been a statement made about how large Glades County is. And the question I want to say, or the statement I want to make is, we're talking about potential mine in a residential area. And I know it has to go to planning and zoning, and I know it has to get social exemption. But the gentleman that is looking at has purchased this area, purchased this land, knew it was a residential area in advance, and had to assume that he was going to get permission to be able to build his or do his mine. Residential. And very clearly in the school zone, if you put the point of rural road versus, or residential road versus county road, you can make that correction so that school buses, trucks cannot go through a residential area to pass by a school zone. Sorry. Apologize.
I think their attorney said that they're not allowed in residential areas currently. Is that correct, Mr. Pringle?
Through active subdivisions, active residential subdivisions. But again, the mining site has to be located in OUA, light industrial, heavy industrial. I think there was one more, agricultural. I think were the four categories, zoning categories. So all this conversation relates to the hauling route, and the hauling route going through a school district, the hauling route going through residential areas. That's what you're talking about, is the hauling route aspect of this. And again, the Planning and Zoning Board, or as recommended by the chairman, the Board of County Commissioners can add additional conditions on a case-by-case basis to address that as well.
So tell me then why, so if we want to put no trucks can go to a school zone, why did the planning and zoning not want that?
My recollection was, as I had stated previously, is that there was already a mining operation that goes through a school zone. They have a school crossing guard every morning and every afternoon. There's signs that.
But they would be grandfathered in, right?
Well, that's US 20. That's US 20. Right. That's US 20.
Because basically, if it comes to me, I'm not gonna let them go to a school zone if it comes to special exception to me, so I don't have a problem putting it in there. We're gonna have to go around one way or the other. I mean, I'm only one vote here, but that's my opinion. They can go out Fire Tower Road, they can go whatever way.
Excuse me, Mr. Chair, I would like to remind everyone, this is countywide. And through the special exception, we could deal with each individual case. Now, I know, just referring back to what Commissioner Chairman Stanley said about 27 in the school zones. And this is a huge county. Let's just leave Muse out of it, Mr. Singletary out of it. What are we limiting? How will we be limiting other industrial businesses from coming to Glades County? I'm concerned about the kids. I have 8 children myself. And so I'm not against dealing with each individual special exception. So when we get applications, let's say let's address the elephant in the room, Mr. Singletary, the mine. When we get that, then we can deal with that as it comes. And this is a countywide ordinance that I believe needs to be passed. This is just the first hearing. We've made notes of recommendations to changes. Our attorney has made the notes. Susan has made the notes. And then it'll come back before us. But I believe we need to get past this.
I agree. Go ahead, Mr. South. Any other public comment? Any further discussion? Up to the board.
So you're going to revise the changes we've made?
Yes.
I guess we're going to be in contact with you of any additional changes that pop in last minute.
Like there will be a second public hearing, and those additional revisions can be brought up even then. If the second public hearing is the last public hearing, depending on additional revisions that you want to make of that second public hearing, we can adopt those as a part of a motion to adopt the ordinance at that second public hearing. Or if the changes are too substantial and you want to have a third public hearing, then you can also make that decision. I would suggest that at that night board meeting that you have an item on the agenda to extend the moratorium. If you adopt the mining ordinance at that night meeting, then don't extend the moratorium. If you don't adopt the ordinance at the night meeting, then you'll have the moratorium extension on your agenda, so you can extend the moratorium for a short time. So we can bring it back one more time. So Mr. Chairman, my intention, and I've taken a bunch of notes, is to work with Ms. Susan to prepare a revised draft that will show these changes that have been mentioned. Again, it was especially related to the Board of County Commissioners being the final decision maker. It was related to the if a condition is violated, then the Community Development Director would have the authority to temporarily suspend operations, but then it would come to the Planning and Zoning Board or the Board of County Commissioners for the final decision as to whether the special exception should be permanently rescinded. I think those were the two things that you mentioned. Adding language that says that not only are the roads to be built to the FDOT factors, but also maintained at the FDOT factors. And then there were Mr. McLaughlin's comments about the property owner being responsible for damages and violations, including any amount remaining after the bond. And I said that's already included, but it can have a sentence that also says that. if the board wants me to. I mentioned that the financial assurance is at 125%. If we're gonna be consistent with the subdivision plat ordinance that you already have in place, I can add that if you want me to. And Mr. McLaughlin's other item was that county costs, including the staff and the legal, are recoverable from the landowner and also from the bond/financial assurance. That is also applicable already, but if you want me to add a sentence that says it, I can also do that. Those are all the comments that I have, and then that's it. So far, I believe at this time, the language stays, and I mentioned you can do something in the future with the Muse area if it is appropriate, specifically for the Muse area with regard to separation of mining operations and with regard to school zones and truck routes. You can also address that at a separate time, since that applies at this point, from my best knowledge, to West Glades School. I think that's the only school other than the ones that are here in town. So you can do something related to that at some point in the future. But in the meantime, it will ultimately be in the hands of the Board of County Commissioners to decide what truck route is to be used by any mining operation anywhere in the county under this countywide ordinance. Have I missed anything?
But with all these changes, we're gonna need, I think we should table this until the next meeting. Do you have it ready by the way?
Well, yes, so you'll have one more public hearing. You'll have one more public hearing. The plan is, and that's one of the reasons why I said all I just said, was to make sure I've got the right idea in mind as to what changes you want to make to the ordinance. We'll make the changes to the ordinance as quickly as we can, and then give you, the board, a copy of the revised ordinance, and it will then be available to the public as well. We will mark the changes that we have made, so you'll be able to focus right on those provisions. And then at the 9th meeting, the end of this month, we are already noticed for the second public hearing, and if on the ordinance, and if the ordinance as revised is acceptable by the board at that time, then you can adopt it. If you read other comments by other people in the meeting minutes from today's meeting, and you want to make additional changes, you can call for a third public hearing. It's up to you. You still have full decision-making authority, Commissioner Sapp, at the next public hearing.
Right, so you make a motion.
Well, so you would, based upon all the direction, it would be a motion for us to make revisions and bring it back to the board at the second public hearing with revisions.
Mr. Chairman, I move to
direct staff to make revisions and bring it back to the board at the second public hearing.
what he said.
So
I'll second that.
I got a motion by Commissioner Sapp, second by Commissioner Whidden, to make revisions and bring it back to the board. Do we need to do a roll call here, or just a?
at this point, it's the first reading, simple vote. You're not adopting the ordinance today.
Is there any discussion?
Man, I won't be done on this, but one more thing, any mine that happens in Glades County is gonna have to have a special exception to.
Yes, in all cases, yes, sir.
Yeah, so this is the baseline.
Yes, sir.
The special exception permit is to catch up on what it.
Correct.
Yeah.
And you will have that opportunity, you will have the opportunity at the time of your review and Planning and Zoning Board's review of a special exception application. You'll have the opportunity to see conditions recommended by staff, conditions recommended by Planning and Zoning Board, and then you'll make the final decision. And you can add conditions in addition to the baseline established by the ordinance.
I got a motion, no discussion here, I wanna ask for public comment one more time. Yes, ma'am. Come up to the podium, please.
No, I just, the date of the night meeting? 26. Thank you.
So, with no further discussion, no further public comment, all in favor?
Aye.
Opposed? Passes 4-0. All right. Next up is our consent agenda, which is number 2, county warrants, number 3, federal equitable sharing fund, DOJ request, number 4, local law enforcement trust fund request, number 5, approve the minutes of the July 9th, 2024 regular meeting.
Mr. Chair, I make a motion to approve the consent agenda.
Motion by Commissioner Whitten, second by Commissioner Scott. Any discussion? All in favor?
Aye.
Opposed? Passes 4-0. All right, public input on business agenda items. Anyone wishing to provide public comment on an agenda item, please fill out comment card on the table at the entrance to the commission chambers. Please note all comments on agenda items are limited to 3 minutes and/or the board's discretion. Business agenda number 6 is request approval to purchase a new commercial fire truck to replace engine number 11.
Yes, sir. Our Public Safety Administration, they're all at a conference, so I'll be handling this one. We have located a fire engine to replace engine 11, which was involved in an accident. The company who actually, the dealer of that truck, had requested that that the board actually do an intent to purchase. We really can't do a purchase order or a contract yet. We have not received the total funds from the insurance company yet, but we did want to be able to assure the dealership that we have an intent to purchase. So really today, all I would like from the board is just a motion of an intent to purchase. Once we receive the insurance funds, then we can issue a PO. This dealer is on the state bid, so we are not going to have to go out to bid to purchase the fire truck. So really today, I would just ask that the board move to provide an intent to purchase rather than issuing a PO. Right.
So the majority of the cost of this will be absorbed through the insurance.
Yes. And maybe that's up to the board. If you would like to authorize the purchase now, or if you want me to actually bring the actual purchase back. The insurance company has said we'll get around $411,000. The truck is priced at about $476 right now. So there is a small difference that we will have to come up with funds. I did talk to you about that this morning, so we're okay there.
But the price is $476. That's a. I mean, we gotta have a fire truck. Right?
Chair, I move to approve the purchase of a new commercial fire truck in the amount of $476,000.
Motion by Commissioner South, second by Commissioner Taylor. Any discussion?
Yes, if we do the intent, I mean, this is going to be the price of the truck.
Yes.
We're not going to see a $600,000 bill.
Correct.
Oh, but if we don't do it now, the price
It
will
might
go
go
up.
up. Or they may sell it out from
Or they
under
may
us.
sell it.
Yeah.
Any further discussion?
And just to your point, the maximum authority that's in the motion is for $476,000. There's no authority beyond.
All in favor?
Aye.
Opposed? Passes 4-0. Number 7, 2024 demo reconstruct company an additional alternative for a new home or property.
Good morning, Cindy Ricker for Red. This is in regard to a demo reconstruct strategy for Ms. Humphrey. I went out for bid. There was only one company that actually came to the bid, and we did receive their bid. It was for a 2-bedroom, 2-bath house. The amount is $245,500. That did not include the septic, or it does include the hookup now to a sewer. After going to our house, I thought she had a septic because she's still hooked up to her old one, but she is on sewer. So I went back to the bid and I said, does this include you hooking up to the sewer and abandoning the old one that hasn't been abandoned yet? And she said, yes, that would cover that. Now, there was an additional clause that she had put in that, if there was additional dirt or rock or whatever that has to be brought in past 40 loads, there is a charge for each load after that at $400 a load. So it potentially could go more than $245. So with saying that, I look for an alternative because of the cost. And I did reach out to Stanton Mobile Homes, and they gave me a quote on a mobile home, which at this time, with the percentages that we have, the 20% on our of the fund that we get, we can do on mobile homes, and with the income that we have that has not been spent, that we've received from interest, we've gotten some money back for some houses. We could do the mobile home. We would be within the guidelines for the house. So I'm here today to see what your thoughts were and what you would like me to do with this.
Excuse me, Mr. Chair, I know that Shep, we only get $350,000 a year,
Yes.
correct? And I know we have some that we haven't used yet, but I believe the mobile home is a alternative.
And that is what is
Just to
currently.
be able to help us, to be able to help more people. And I lived in a mobile home for years, right through hurricanes and everything, didn't have a problem.
Does the quote for the mobile home or whatever we call it, does that include demo?
Yes.
I didn't see demo.
Excuse me, it will include demo. They have to go to their contractors, but I estimate that to be somewhere between 6,000 and 8,000 has been my experience with seeing that done.
So that, is that included in the 120?
No. Yes, sir. That's what I added on to that.
I see that one was 115, so
Right, I just added on 8, just to be sure, just to give us.
we used to be able to do a concrete home for 120,000.
I did the first one here for 98,000.
It's crazy the way
It's
things are
really
done.
crazy.
And I'm not against anyone having a new home, but
Right.
to be able to help more people, and that is
And
way
that
over
was
half
my-
of the money that should
Yes.
This
receive.
meets all the hurricane.
Yes,
standards and
yes, they're
everything.
all up to
Well, I don't have anything against mobile home. I've spent half my life in a mobile home. But I'm leery about making that investment because, man, even the best manufactured home in 10 years, you're redoing the counters, cabinets, the whole, they're made lightweight so down the road. I'm leery of making that investment. But we're,
What is the mortgage on this one? I mean, how many years do they have to hold it before it goes to them?
10 years.
It's 245 or 123. I'm inclined to go with 123. 10 years, I can buy another house. The big one, but I'm sure the trade of the last 20 years or better. I know there's a bunch of buckets that are even older than that.
Excuse me, I did check on the availability. This particular mobile home is sitting on the lot as of last week, unless they sold it over the weekend. If they do have to bring another one in, it would take about 4 months to order that and get it in. The house you're looking at over a year for them to be out of it. So the time frame for being out of her home is another thought that I had.
I mean, not that she gets a choice, but I mean, you know, the complaint of, or does she even know?
She knows I'm bringing both of these, and the contractor knows I'm doing that also. I was very transparent in that.
Mr. Chair, I move to approve a single-wide manufactured home from Stanton Mobile Home Sales for $123,000 for reconstruction park strategy.
Okay.
Motion by Commissioner Taylor, second by Commissioner Sapp. Is there any discussion? All in favor?
Aye.
Opposed? Passes 3-1. Mr. Glidden. Opposed. All right, number 8, proposing changes in current 2022, 2023, 2023, 2024, and 2024, 2025 LHAP local housing planning assistance.
After looking at this and getting the bid in, and it was so high, and knowing that we have pretty much spent the money that we had for past years, and we're getting to where we will just be receiving the $350. We don't have that cushion. I want to suggest that we remove the demo reconstruct strategy out of the LHAP at this time. We can always put it back in if necessary. But as Ms. Taylor was saying, at the price of houses, even at 123 going forward, this was in the last year, the other house. I'm not going to be able, SHIP is not going to be able to help as many people with roofs or septics, things that have to happen right away. Where, I mean, we can always make an exception if the house burnt down and we had to do something. I mean, there's so many people that need just everyday needs to be able to be in their house. That would go further with more residents, and I think that is necessary at this time. So that was one of the changes that I put into the LHAP for you to consider. The other one, I started putting roofs on some of these houses, and the roofs have been $12,000 and up. There's been I don't think any one was $9,000. But the condition of some of these roofs have been horrendous. I have pictures on them where 20 sheets of plywood have had to go on the roof to secure it. And then saying that the new systems for the septics, they have a new system now that they have to do depending on what size your lot is, and those could be as much as $20,000 plus for a single family home to have if you have less than an acre. So with those things in mind, the $15,000 for emergency, I don't believe is going to be enough. Because we can always get less, but if I have to come and ask for more money each time that this happens, it would stop us from taking care of the emergency to begin with. So that was the other thing I'm recommending to change in the LHAP.
Mr. Chairman, I move to approve the changes to 22, 23, 23, 24, 24, 25, local housing assistance plan, and authorize the chairman to sign on behalf of the board.
Second.
And then Mrs. Bouchon, she reminded me, I did change some of she helped me, the fonts and the changing of how the LHAP was written. It was not correct, so we readjusted that. So that was the other change
So all the changes that we're making, they're basically supported through law. And I know, I hate to see, I got a guy living in a shed on 7th Street. He needs a house, but I don't think he could afford to take care of this with building fund. But all right, so I got a motion by Commissioner Sapp, second by Commissioner Taylor. Is there any discussion? All in favor?
Aye.
Opposed? Passes 4. Number 9, satisfaction of SHIP mortgage.
This recipient has completed their term, and their agreement. And I would like to ask to have this satisfied at this time.
Mr. Chair, I'd move to approve the satisfaction of ship mortgage and authorize the chairman to sign on behalf of the board.
Second.
Motion by Commissioner Whitten, second by Commissioner Sapp. Any discussion? All in favor?
Aye.
Opposed? Passes 4. Thank you. Number 10, Glades County Evaluation and Appraisal Report.
Good morning, Commissioner. Chair and Commissioner Susan Johns for the record. And today I have in front of you a proposed schedule that the county has to do. And it's called the Evaluation and Appraisal Report. And Evaluation and Appraisal Report has to do with updating your comprehensive plan, making sure that you're in compliance with any changes the legislature has made that would affect your comprehensive plan and its various elements. That has to be done every 7 years according to the Florida statute. However, if you don't need any changes, you would have to send a letter in to the state and let them know that you're in compliance. However, the county's comprehensive plan has quite a few areas that need to be updated as far as changes from the legislature and just changes in the document itself. And it's important to keep your comprehensive plan updated, especially through the year process. So say, for example, we'd have to have this year amendment, sent to the state by May 25th, 2025. And that's just your transmittal. That's just that's us doing all the work and then sending it up to the state, and then they can come back and give us review comments, and then that adds another timeline. If we don't meet that date of March 25th, 2025, the county can no longer do any comprehensive plan amendments until it's completed. So it's very important that we meet this deadline. The comprehensive plan, as you all know, it sets what your vision is for the county, how you want to see the county grow. And through that process, you come up with goals for each one of your elements that's in the comprehensive plan, and then you have some following objectives and policies to support what goal you have. And that's something that's going to go in front of the Planning and Zoning Board and then come to you for adoption. And also, it's important because the comprehensive plan helps you guide your growth and where you want to go, because it's a minimum of a 10-year period. So and we know that parts of the county are changing up in the Buckhead Bridge area and up around the reservation. So there's going to be some things that we might want to look at based upon how the demographics will be changing within the county. And the other reason the comprehensive plan is important is because it is implemented through, in other words, we put into effect your comprehensive plan through the land development regulations that have been adopted, subdivision regulations, the capital improvements plan, and any environmental regulations that we may have. All of those support your comprehensive plan. In other words, it's giving you guidance on how to have these other regulations implemented. In your comprehensive plan, there are 11 elements. We have the future land use element, we have the traffic circulation element, the housing element, infrastructure element, there's a conservation element, recreation and open space element, we have an intergovernmental coordination element, capital improvements element, there's a public school facilities element, an economic development element, and a property rights element. Each one of these elements will be looked at for consistency with the legislature, and then also any guidance that we get from the Planning and Zoning and the Board of County Commissioners. So people may say, well, what is an evaluation and appraisal report? Well, number one, it's required by Florida statute, the growth management law. This has to occur every 7 years, and if we don't go through each element and our staff goes through it and finds out, okay, we're still in compliance, then we just submit a letter. But if we're not, then we have to go through this process again. Any changes to any of these amendments in the comprehensive plan. Like I said, it has to reflect state law. And another thing the EAR does is it helps the county take the time to stop and look at your comprehensive plan and determine, is this really how we want the county to go and grow in the next 10 years? And then also, there will be some public planning, a workshop for the public to attend and see if they have any areas that they think they would like the county to consider, to see if there's any areas or problems that maybe could be addressed through the comprehensive plan. So something they may bring up, maybe we can address it in the comprehensive plan, and then maybe it's something that's could not be taken care of in this document itself. So the workshop that I'm planning is September 4th from 5:30 to 7 o'clock p.m. and it will be at the Doyle Connor Building. I have not put an advertisement out yet. I just wanted to come here first and present everything to you. And it's an opportunity for county to seek public input as we're updating this comprehensive plan. And I did provide you in the packet a tentative schedule. So I started with the month of August, and that will be today, kicking this off, giving you the presentation of what the work has to be done. And I anticipate the work will go all the way out to spring of 2026. That's how long it's going to take to go through this process if everything is followed and there aren't any hiccups. That date could extend depending upon if the Department of Florida Commerce has any comments that might take us a little while to respond to, but there are deadlines involved. Florida statute has that we have to follow. And then, of course, we could be challenged, and if we're challenged, that would extend beyond here, March of 2026. So this is what's coming up for the citizens and for the Planning and Zoning Board and the Board of County Commissioners.
Do you know what September the 4th, what day of the week that is?
Wednesday. I haven't advertised, so if
I haven't looked on our calendar with me, but I would like to be at these meetings because I don't want, in the end, that planning and zoning and everybody did everything, and then I'm looking at a final report again. So, because there's a lot of areas I think that we need to look at and change some of the stuff.
I can forward the notice to each one of you in an email. I'll do the same with the Planning and Zoning Board. And if it takes longer, then
and
that's
these will
fine.
be publicly. I mean, so if board commissioners show up there at this thing, we're going to be legal, right? Those workshops.
Want me to include that we have the Board of County Commissioners and Planning and Zoning
We'll
Board?
make sure everything's, just don't make any decisions.
So this is an exciting opportunity. Your comprehensive plan only went through 2010. So this is something is going to be good for the county. And with your help. Any questions? Okay, thank you.
Susan, what was the time on September 4th? Your time of that workshop on 4th?
5:30 to 7.
5:30 to 7. I had 7 to 5.
7.
All right, number 11 is a request of approval of a planning advisory service agreement between the BOCC and the Central Florida Regional Planning Council to update the Glades County 10-year water supply plan and related comprehensive plan amendment.
Good morning again, or good afternoon. Susan Duchamp for the record. Glades County has a water supply plan, and it was adopted by the board in 2009. And there has not been any updates since 2009. And this is something that we'll need for the comprehensive plan as we go through the EAR process, but this is important because of the development that's coming into the county so that we have an idea of all of our water and wastewater provisions here in the county and any proposed future changes. And we have reached out to Central Florida Regional Planning Council to do this agreement with. They are another government agency, so it does not require that it go out for bid because they're another government agency. There will be a budget impact to the Board of County Commissioners, and that would be $15,000 is what Central Florida Regional Planning Council is proposing. And with that being said, Jennifer Codell Salisbury, who's the Executive Director with the Regional Planning Council, is here to make her presentation.
I came with paper.
Good afternoon, and thank you, Sue. Yes, as Sue said, I'm Jennifer Codell Salisbury. I'm with the Central Florida Regional Planning Council, and I just handed out just a couple of slides. The 10-year water supply plan is required by Florida statutes, and really it's to make sure as we look at our population growth, both residential and non-residential, that we have enough water to serve those populations, not only today, but into the future. And it actually looks at 10 years and 20 years. And it goes hand in hand. The South Florida Water Management District is they're completing their regional water supply plan. And we're in the lower Kissimmee Basin, hopefully I said that correctly. So that plan has been wrapped up, and our plan for Glades will be consistent not only with looking at our populations and our water supply, but consistent with the regional water supply plan as well from the South Florida Water Management District, and that's required by statute. And as Sue said, this is very timely with the update of the county's comprehensive plan as well. And through this effort, we also look at the policies in the comprehensive plan, making sure we are consistent with policies planning forward, and also looking at our level of service standards and any conservation measures that can be implemented as well. It's I'm just available for any questions, but it's just one of those statutory requirements as well.
And as you can see, the funding for this is included in this year's current fiscal budget as well as in next year's proposed budget. So there is funding available. And I've provided you with a recommended motion.
Mr. Chair, Ms. Bishant, in getting this plan done, is this going to help us in reaching out for grants for sewer and things of that nature?
I believe it would.
Because it's required, we haven't updated it in so long, it absolutely will.
That's, I know our whole sewer system here, I mean, we're very reliant on these grants and anything we could do to.
And both of them have not been updated, one 2010 and the other 2009, so this will be helpful.
For this being absolutely needed and a statutory requirement, Mr. Chair, I move to approve the Planning Advisory Services Agreement between Glades County Board of County Commissioners and the Central Florida Regional Planning Council in the amount of $15,000 to update Glades County's 10-year water supply plan and related comprehensive plan amendments, and authorize the chairman to sign.
Second.
Motion by Commissioner Taylor, second by Commissioner Whitten. Any discussion? All in favor?
Aye.
Opposed? Passes 4-0. Good luck. That's a big document to read. All right, number 12, request to award the bid for Canada Drive from County Road 78 to northern terminus of Crescent Avenue Southwest from County Road 78 to Everett Street Southwest Research Link Projects to Ajax Paving Industries of Florida, LLC.
Yes, sir. This is a project that we've been working on for quite some time. We did receive bids back in January. When we received those bids, it was determined that we didn't have enough funding from FDOT to actually complete the projects. FDOT did step up and find us about $500,000 additional funds, and Ajax Paving did agree to hold their bid price until the end of August. So we need to award this before the end of the month. So I'm asking that the board award the bid to Ajax Paving for a total for both roads of $877,279.55.
Right, and I would like to add, Mr. Bolton, I did take a ride out there, Crescent Avenue, and it's unbelievable. And I'm happy that we're finally able to do something.
Glad we got it done in June. But it's been in there.
I'd move to approve the award and the invitation to bid to Ajax Paving Industries of Florida LLC for Cornelia Drive, FPN 4463227-1-54-01, and Crescent Avenue, FPN 4463224-1-54-01, resurfacing projects in the amount of $877,279.55.
Motion by Commissioner Whitten, second by Commissioner Sepp. Any discussion? All in favor?
Aye.
Opposed? Passes 4-0. Hopefully that will get that road paved quickly. Alright, number 13. Let me make you guys go last. Ordinance creating an exclusive franchise for Okeechobee Utility Authority. This one's on OUA, unless you want to do that one. That's good. They're both basically going to be the same thing, so.
Mr. Chairman, you can take them in reverse.
All right, let's start with Lakeport. We're going to change 13 to 14 and 14 to 13.
Good afternoon, Steve Muni, PO Box 1118 in Gulf, Florida. And I'm happy to say I don't have the controversial item today. So we had, as you know, met a couple times with regards to the proposed ordinance, and I appreciate Mr. Pringle getting it ready. I had some suggested proposed changes that I'd like to just hand to everybody. I don't expect anything today because today is the first and three. I believe for adoption purposes, it'll be coming up on the second reading in September. So I have highlighted in red the proposed changes. Most of them are maybe some semantics. If you'll see on page 2, we're requesting, Lakeport is requesting 50 years with regards to the franchise term. And the reason being is that it's anticipated that we will be obtaining financing through the USDA, and normally their financing terms are 40 years. And as you all know, we're coming out of the ground, so it's going to take several years to get up and going. We're currently in negotiations with the tribe to get some of the jump start for infrastructure put into place. The tribe, if you recall, has agreed in principle, although we have to work out the details, but they've provided a letter of intent that the transmission to their plan for treatment and disposal will be the methodology that's used by Lakeport, at least initially. Down the road, it may change, but that's not anticipated for a long period of time. So that's why you see a longer term than perhaps what you might be accustomed to seeing, but we believe that it would be appropriate. One of our concerns is that with regards to USDA, they're fairly rigid of their criteria. And if they see something that doesn't mesh with their criteria, like a shorter term, that might impact the ability to get financing. So that's why we've done that. And then on page 3 and section 5, and you'll see in section 7, I had some verbiage added with regards to the rates. Obviously, we're a not-for-profit entity, so we don't anticipate charging rates in excess of what is needed to operate. But that operation includes obviously different components, but it's not a for-profit entity, So we hope that the rates will be on par with what's reasonable and necessary, but in the event there is a need to increase rates, especially, and you'll see in section 5, if it's in conjunction with some sort of financing through the Department of Ag, U.S. Department of Ag, or the Seminole Tribe, that our board has the flexibility to adopt the rates. But you'll see in both of those sections, I put language in there that any rate increase would be subject to a rate study. Obviously, we'd have to do that anyway, especially with USDA. But we're, from our engineering side, are going to need to have a rate study to justify the rates that we're going to impose at whatever given moment. So we're not trying to usurp this board. We'll work in conjunction with the board because we're trying to be semi-autonomous, although we're under the auspices of Glades County, but semi-autonomous to the extent where if we need to operate, we don't need to keep coming back in front of this board. And I don't think you want to be cluttered necessarily with us coming back every time something needs to change. So it gives a little bit of flexibility. But as I said earlier, these are proposed language changes. Richard really not had a chance to go through them because I didn't get them done. My typing is a little slow, so I didn't get it out till last night. So, but I at least wanted to get out in front of it because I won't be at the next meeting or night meeting. I'll be out of town for that meeting, but I will be back on the second reading, the adoption ordinance, in case there are some other changes or we need to discuss anything in particular. So with that being said, what I've proposed is the request at this point in time. We do appreciate working with Glades County and getting this onto the agenda. We hope that we can timely get this enacted. We've already had discussions, as you all have heard, with the tribe. There's also some other future development plans that we've heard from some developers. So I think this at least needs to get in place ASAP, so this way we can mesh with what the county and the tribe are doing out there. We don't have to tear things up twice. So that's really the essence of what we're doing. So we appreciate your consideration. If you have any questions at this point or later, whatever the case may be, like I said, I'll be back later. So, and I'm sure I'll be chatting with Richard a couple times in the interim about what he sees in red. So, thank you.
Thank you. I'm glad this is finally here.
Yes.
But, so basically we don't, all you need is just the board's consensus to.
Yes, sir. The purpose of me placing this on the agenda was so that you could see first that I finally got it done. You can laugh at that. Second, that
I'm crying, I know.
yeah, as painful as it is. I really don't like my back turned to Commissioner Peck at this moment. And you're not even listening to me, Commissioner Peck. I'm sorry. I'm sorry to wake you up.
I never did.
The meeting's gone so long that you're passing out from lack of nutrition, right? So it's here before you today only to give me input. There were two blanks in particular. One related to the time frame. Attorney Remuning has inserted a recommended time frame of 50 years. I had no idea how long you wanted to go with the time frame. This is an exclusive franchise. And so if a 50-year time frame is recommended by Attorney Remuning on behalf of Lakeport Water Association is acceptable, that's what we'll use. Also, there was a blank for the legal description of the area to be served. Again, Attorney Remuning inserted an area in the document, and
You all may recall when we did the potable water franchise about 10 years back, and this is also including potable water, so just to have them run at the same time for billing and collection purposes, there was what I call the Lakeport territory. So there's already a map, and there's already a full legal description of what was previously adopted by this board, as I term the Lakeport territory, Lakeport service area. I think we have that shown in this document. So.
And if it's okay with the board, we'll use that same legal description.
That was the intent, yes.
Okay. So if you want me to use 50 years, I will. If you want me to use that same legal description, I will. Attorney Remuning and I can talk about the final language that we'll include for the public hearing review of the ordinance and for the ordinance adoption. I would also point out that the way that I wrote this ordinance, I added language to it so that it can be viewed as and actually is, a binding agreement between the parties, so that when the ordinance is adopted first by the Board of County Commissioners and then the authority approves the adoption of the ordinance, they can just sign off at the bottom of the ordinance, and then that will be the agreement between the parties and we'll be done with it. So that I don't have to come back again. So that you don't have to wait on me to come back again. How's that?
That'll work.
So that'll button it all up and you'll be able to have it finished at the time that this ordinance is adopted and that the authority approves. Is that okay?
Yes,
Okay.
perfect.
Okay.
Thank you.
You want me to do anything different from what you got in front of you?
Well, I haven't really read the whole thing, but it sounds good.
Okay.
I think the Okeechobee is pretty much similar, although Mike,
It is.
you'll see Mike tweaks versus, I don't know, I don't have any comment on that.
But it's, and I'll try to make them consistent so that as much as I can. That's one of the things that I did determine in the research. And by the way, Mr. Ramuni has been extremely helpful in assisting me in getting this done. So he's been very helpful in that. But anyway, one of the research items that I did look at, based upon my concern with the county granting exclusive franchises, is that you should try to be consistent in granting exclusive franchises for similar services. You should try to be consistent in the requirements and obligations that you describe in your exclusive franchise. So we'll do that and try to make these two consistent.
If that work for you, then yeah.
Yes, sir. So we'll have them, and I'll have them both on your agenda. I think we can get them noticed and get them on your agenda for a public hearing at your night meeting. That's the plan.
Okay, great.
No action is required.
You guys have expressed to us the time sensitivity behind it, so I hope this meets you guys' needs.
It does. Thank you.
And I would assume this line goes to Indian Prairie Canal, is that?
That is the upper boundary.
And depending on how this outcome comes with Okeechobee, we might be asking you guys to expand. But I was supposed to meet with them next Tuesday, and I just realized that next Tuesday's election day. I don't think I'll be out there with them. But
I mean, there's even a thought where it's a little bit ahead, but you know, especially in that end of the county where we work well with the authority and we're the auspices of the joint authority of the city and the county. I was talking with Connie a little bit about this too. At some point, there might be a need to perhaps expand the authority. I don't know. That's much down the road, but at least gives you a working mechanism to go by. But for the time being, this will get us going for the next however many years. I probably won't see that, at some point in the future. But yeah, if you have issues with that, we certainly can look at that as well.
Expansion of the boundary is a lot easier to do than the creation of the exclusive franchise in the first place.
Sure.
So we can always do that if it's appropriate, beneficial.
Thank you.
So no action is required. We'll get it before the board for adoption, and you have 2 public hearings to complete the adoption process. And then, Mr. Chairman, you took them out of order, but OUA is exactly the same thing, so I can do the same revisions and get it fixed up and get it before you for a public hearing as well, unless you have some other comments. And that area, I mean, I wanted to make sure that area, that will include lakefront estates.
well, the last one that they sent to us, they cut it off at the access road in Buckhead, so I've got to go talk to their board and find out.
Okay.
But I don't think it's the board itself. I think it was one person. But anyway, I got to find out from them. But I was going to go to their board meeting next Tuesday, but I'm not going to be able to make that. So we need to get this document to them and see if they're going to bless it before we bring it in here.
Yeah, I think Mr. Connolly, their lawyer, I sent it to him when I sent it out to you. So right, you got it that time. I sent it to Mr. Conley at the same time that I sent it to Attorney Conley at the same time I sent it to Attorney.
So I will try, we have one representative on that board from Buckhead Ridge, so I know he's in favor of keeping the old district, but I don't know, I have to find out. They changed boards around, so I have to find out.
Their district used to go all the way to Indian Prairie Canal.
Yeah, it
from
did.
the lake to the reservation.
Well, it was from the river to Indian Prairie and a mile and a half on each side of 78 was their boundary line. But I don't know, for some reason, the last one that they sent us, they didn't want to go past Buckhead Ridge, you know, so, like I say, I don't know if they just don't want the heartache or what. But
currently, Mr. Chairman, the draft ordinance says that the general legal description, or the general franchise area is generally described as being 1 1/2 miles on either side of State Road 78 between the Kissimmee River and Indian Prairie Canal. That's what you were saying.
Except I was wider than that, what I had. That was several years ago that I had. I'd have to go back and see where I came.
Okay. Well, that's the big question for me. The two big questions are the time period and legal description. So if somebody can provide that to me, then the document is ready to go.
Well, they had come to me, I don't know, a year or so ago, and they wanted to expand that 1.5 miles out to 2 miles because they had somebody live out there that they wanted on their board. But I told them that we just can't change the thing like that easy. So, I don't know. We'll let them decide on. But I'm going to very much push for them to keep at least the existing district for now. But we'll see where we get there.
I need that for the ordinance.
And that needs to be done by next meeting.
Yes.
Gotcha.
Thanks.
So, so both of these items, we're good. We don't have to do
Yes.
anything else?
No. So I don't think you need no action.
Sorry that y'all had to wait. You've learned a lot about mines today.
Thank you.
All right, moving on. We'll move
Mr. Chairman?
Yes, sir.
Excuse me for breaking in, but I would like to thank the board and Richard for diligence and working and getting all this thing together. Good things for all of us are going to happen.
Thank you.
Jim too, she's been very, very.
Thank you very much. Good thing we had it today, or that story would have been a whole different. All right, we will move to constitutional officers. Tammy, you got anything? Who else we got here? Anybody from the sheriff's department over there?
Sheriff Hart, do you have anything?
Get out and vote Tuesday. Other than that, enough words have been said here today.
Let's see. I don't see any other constitutional officers. County attorney.
Yes, sir. The item that I want to bring to your attention that is in addition to everything else that we've discussed today is that with regard to County Road 721 and the interlocal agreement with the tribe, I expect that there is going to be an amendment to that interlocal agreement. If I remember correctly, the entire stretch of the road from the county line to State Road 78 is going out for bid. All the design documents are done and it's going out to bid like really soon. And there was discussion between AIM Engineering, your engineer, and FDOT about the inclusion of the section of the road, phase 1, that we have under a grant agreement, and possibly having that bid on at the same time that the rest of the roadway is also being bid on, so that one paving company contractor can bid on the entire length of the road, our part and everybody else.
They've already bid that and awarded it.
Yeah, but we.
Right, versus after.
That's what I said.
Okay.
Yes,
I was gonna say, they're paving.
They're paving,
Yeah.
right.
No, so, but they wanted the same contractor to also bid on our segment as well. And that's what we're in the process of doing, and FDOT said okay to all of that inner workings. And AIM Engineering is doing a good job for the county. They are providing some independent contractor services to review the plans for the part of the road that the tribe is
Yes, they are.
doing. AIM Engineering is reviewing those segments of the road as well. So, for your benefit to look over their plans to make sure that everything is okay for us. Because ultimately it's your county road, and you'll ultimately have the county road as your responsibility in the future. So, is there any update? Is there anything else on the agenda? That's all that I know of. That's all I know of.
Anything for the county attorney?
Just for the attorney and Miss Susan, and whoever else might can get the ball rolling on the business part. We've been discussing this for a while now, and
I'll call Ben Smith. He was the gentleman, Morris Depew. They were working on the actual plan, the proposed plan. I have not called him recently. We'll call him maybe try him this afternoon.
all right, that sounds good, because I know I don't want Glades County, we have opportunities there.
Yes, ma'am.
And we have opportunities that I want to take advantage of before they go somewhere else or change their mind. So, thank you.
I don't know, Connie would probably know, but Florida Commerce just put out a grant, opens up September 1st for, it's $15 million to do upgrades like in there and stuff like that to, it has to create jobs, it has to create stuff, but maybe we could apply for some of that to finish the infrastructure right now.
It's, the grant opened August 1st, and it closes September 16th. It's the Rural Infrastructure Grant Fund. They have three different applications. They have the planning grant, it's a maximum of $300,000. You don't have to have a match. Well, we wouldn't have to have a match because we're RAO. And then total participation grant is, includes construction. So, depending on where you're at, and your comprehensive plan plays into their documentation as part of the requirement. If it has to be amended to meet whatever is going to be done in the park, that would have to be done to go with the application, whether it's a resolution or an ordinance or to make the change to the plan. So part of that is included in all that documentation. But they had a webinar this morning.
Okay.
So after we can get together a little more detail, start the grant application. If we can get everything done, boundary map is part of it. It's a complex application, so it's not very documentation.
So what we're paying Depew to do now is the plat, or are we paying him to do what?
We are paying him to give a recommendation of a plan for a master concept type plan for the business park, for the remaining parcels in the business park that are still owned by the county. And that includes a discussion of how to subdivide the parcels and whether you subdivide, whether you do a subdivision plat now or whether you do a plan development approval for the entire park, business park, and then later on do a subdivision, or just what those steps are to get it across the finish line and to be able to sell maybe a parcel or 2 parcels or something like that sooner, and then have the rest available for future development and sale.
Well, any of those steps that we need to do, if we can get, I mean, if it's planning or whatever, if we can get some of this money, it would be great for us to apply.
Sounds like planning.
Yeah, I don't think we're ready for construction or anything yet.
Well, except for that road, the completion of the road, but there's a possibility, I haven't heard anything from FDOT related to a license agreement for the rerouting of traffic around that intersection. So, you know, at one time, they were supposed to come and do some more work, FDOT was, as part of that license agreement.
I think they're still planning on it.
That internal road I'm talking about, that would, that they would
Right.
complete the road.
And if I remember correctly, Florida Commerce, I almost said, would like things to be completed in 12 months' time. There could be extensions to those agreements with circumstances, but usually their grants, they want everything done within a 12-month time frame. So would that happen? That's a question.
I don't know, but we will
Yeah.
definitely look at it, because when I see dollars out there, I wanna get them.
I understand.
Yes, ma'am.
Something else for Mr. Penny as well.
Anything is possible.
All right. Do you have anything else while you're up there?
We're just, the legislative calendar, after the elections, November 19th in Tallahassee, they do their organizational session. So once that is completed, the delegation hearings can be scheduled at any time after that. At this point, the committee weeks have not been scheduled, but they will be held in January and February. So our timeline to be ready for our legislative budget requests and priorities should fall, around that November 19th or earlier, if possible. Usually the House funding request form shows up, the deadline is usually during committee weeks, and they've been kind of having it early. I want to say the first month of the committee weeks is when last year's deadline showed up. So I just want to be prepared, plant that seed. Now's the time to start planning for that process. And as far as our wastewater grants, nothing new to report. They've been submitted as we reported your last meeting and at the CCPWA meeting for the septic to sewer improvements and the wastewater plant expansion. That's been submitted. The grant administration for the sheriff's office, we're working with staff on that with the monthly reports. The new DEP grant for phase 6 of the Northeast Septic to Sewer agreement's been here. I've worked on the initial report for Office of Policy and Budget. It's the return on investment. I've got a draft of that. I haven't even sent it to June yet. So that's been prepared. So we're moving forward with that. And I believe that's all I have. And we're doing funding requests for the US 27 corridor project. Do you have any more questions for me?
I got money.
Okay, thank you.
Thank you. All right, county manager.
Yes, sir. At the last meeting, I requested that the board set a date. There was interest in a workshop for the water storage areas for the moratorium on that. We have been contacted, Commissioner Sapp has been contacted by Likes Brothers asking if we could move that date. And then I also received an email from the Water Management District asking us if we could move the date because they were not going to be able to be here at that time. So currently it was scheduled for September 10th. The requested date from the Water Management District was October 8th. So I was just wondering if the board would be interested in moving that to the 8th of October, which is a day meeting.
I'll be that busy.
I guess the 10th of September is the same day as their governing board meeting, so they could be here.
What time of day?
Right after our regular board meeting.
And we have board meeting on the 8th.
Yes,
Yes.
sir.
I don't have a problem with that.
I don't even have a problem if we do a special meeting for this. If the night meeting runs like this, or the next day meeting runs like
It could be long,
this,
right?
It's gonna be long. But yeah, it is something I'm very interested in doing, is sit down. Likes has reached out to me to meet with some of my concerns about water storage. I'll be meeting with a couple representatives tomorrow for that. But yeah, I'm ready to hash this thing out and just get into the nuts and bolts of it.
Everybody good with the 8th? That would, and then if they can do something earlier,
Okay.
let us know.
Okay, will do.
But is the 8th good with lights?
I have not heard from Likes on a date that was specific.
Like I said, if we have to have a special meeting, we can do that.
I will reach out to
Then
them.
we'd have to advertise, and I think that's 2 weeks.
I can show that, I can convey the 8th is
Okay.
tomorrow. So.
Okay, very good, thank you.
Anything else?
Yes, sir, that's it.
Anybody got anything for the county manager? Okay, we go to department heads, Mr. Bouchon, you got anything?
Yes, I do. DEP has sent out an email that the BMAPs that we have, the county has 2 BMAPs, that's your basin management action plan. What it is you're wanting to reduce the nitrogen and phosphorus that's in the water. That's why you see a lot of these grants for septic to sewer. They're looking for ways to improve the water quality in the Caloosahatchee and Lake Okeechobee. We're in the Lake Okeechobee BMAP, and we're also in the Caloosahatchee Estuary BMAP. And I need to provide them updates on any projects that we have, and that's due September 27th, 2024.
Just on a different subject, 7th Street up there in Blackhead Ridge, I sent you an email that asked you to give me an update, but that guy is living in a tent, and there's just garbage all over the yard. There's a car there with no doors on it, no tires, it's all jacked up. I know code enforcement's been there, but the people up there are getting irate about it. I'm going to ask him today after this meeting if he'll give me permission to hire somebody to just come and clean his yard for me, because I'm tired of getting all the flack over it. But I was wondering if he got a court date or.
I need to update you on that. I don't know. I need to talk to Annie and look at her schedule. I know she has court today at 2 o'clock, but I don't have the list of the items that she has.
But eventually he's got a shed that he's, well, now he's got a tent there. I don't know, maybe Wayne ain't living in a shed no more, but maybe it's too hot in there. I don't know, but eventually the guy can't live in a tent there, so we're gonna have to do something above and beyond just making fun of the yard. I think he's hiding the tent behind the trash right now. So, anyway.
I will look into that and I'll respond to you.
I'm getting crucified over that, so.
I also have some questions about code and their follow through. You know, we had a couch on the way that was on the right of way, you know, and it's, well, you can't see it.
On the right of way?
Yeah, you can't see it now because the grass is over it, but it's still there, I'm sure.
I know if it's in the right of way, that would be getting Archie out there to remove it.
Yeah.
It's not on anybody's personal property.
Well, it's clear the property it came from, because before that was an easy chair that stayed out there for a couple months. I mean, if Archie would come pick up my crap, if I just throw it off of my property, it'll save me a trash bill, you know.
Well,
I want to, you know, kind of get into these guys a little bit, because this is like the 3rd time that they've just stacked crap. The county goes cleans it up, so man, I'm kind of down with that. If I can just throw my household garbage, I save $128 a quarter. That's you know, we can't accept that. They've got to be held accountable. It's obvious.
And what was the street on that?
It's on Azalea.
Azalea? Oh, yes.
Could a bill be sent to them if the county?
That's what I want. I don't mind if we clean it up. I mean, they need to pay for it, because if not, it's pretty cheap for me to just toss my trash on. the other side of the road.
Because it's hard to tell whose property it is.
It's
Somebody
not-
could dump something in front of my house
It
that wasn't
could.
me.
This matches the chair.
It's
It was matching furniture. It's kind of, you know, I get it. You know, when you drive through Azalea, it's a nice neighborhood, short of about a few people. You know, and the guys that are trying to keep their stuff nice. And there's older mobile homes there, but man, kudos to the people that are really keep them nice. Some. But the complaint I'm getting, I mean, I got a pretty nasty response on my phone that code enforcement is just not answering them. They go out, but there's no follow through. They can't find out what's going on. They got a lot of complaints through code. And, you know, our new system is, they're saying it's no better. They had high hopes at first, but they're pretty disgruntled. And whether that's a valid complaint, you know, I just want to know, are we moving? Have these people been ticketed? You know?
Do you want to forward me your email?
I can show you, yes, ma'am. I can show you.
Please do.
It's not, it's a text.
Okay.
There is draft language.
We don't put that on public record. I know, like I can look up a building permit or something online now, but we don't have code enforcement online, right?
Code enforcement's online and people can go on and see, and look up to see what violations there are, which property, all of that. It's through the iWork program. Public has access.
You can also go into the court records and view their, if they have a case with the court, see their case, it's been filed.
I know, I mean, I guess the same process. You go and cite them and they get 30 days to clean it up and then they get a court date scheduled. So, I mean, this has probably been that way for 3 or 4 weeks now, so the guy probably hasn't even had a second hearing yet, but the people that live on that street are just like going crazy.
I do know that the judge has a big trial, so what we had wanted to take in September now has to go to October and October to November. I mean, we've been moved by the judge. But nonetheless, that does not take the fact that I'll look into this, find out what's the status, and see if I need to help Annie.
Okay. That's all I got.
But please forward me.
Yes, ma'am.
Okay, thank you.
Any other department heads that I missed? Don't see anybody. Commissioner's items, we'll start with you, Mr. Whitten.
We've talked a lot today. Hopefully the sandline ordinance, there is a need for it. We've got to have some written rules on what people can do. I think we're moving forward with this. I'm not just saying I want this ordinance for this place or that place. I'm looking for protection. I mean, it could easily happen if they move down the river to Mine Rock and sand or whatever on my road. So I'm looking at how does this protect me as well as every other resident. So I'm hoping we get it right. You know, it's going to be, I'm sure, a living document for a little bit. I hope that it protects all of us. The stench of political season is in the air. There is a stench there. I'm sure the candidates, some of the candidates, and a lot of the citizens will be glad when it's over. And we don't have long left. So good luck to those that are running. Hang in. I did attend Fish Eating Creek, the FWC meeting concerning Fish Eating Creek. I think I left with more concern than I went in with. Very suspicious when Fish Eating, the FWC is over managing Lake Okeechobee. I don't know of anyone running up to pat them on the back for their success in that management. I fear some of those tactics are going to happen on the creek, and it's kind of, as a lifelong fisherman, and somebody who feels that he was pushed off the lake through bad management practices, I kind of took refuge on the creek. And man, I just don't want to see the overspraying, the just doing without thought. I mean, it sounds great. We're going to go in and spray out invasive plants, but when you spray them out, kill them, then you have dirt. And then as the creek fluctuates, we're just silting up the creek, which in turn speeds the lake to make more problems. So it is an issue. I don't live in Palmdale. That's where the creek is, but I think it's a treasure that we all hold that live here in Glades Glades County, and I was kind of amazed at the attendance. I think it was Pinellas County, a guy come down that day and kayaked. It's not just a jewel for us. I mean, there's a lot of people outside of our county who come from that. You see that when you run the creek. You see a lot of familiar faces. Thank God, my last trip 2 weeks ago, I was towed off the creek by a familiar face because my boat gave up. But it's a great place we have. I was proud to see the concern from the audience of the management of it, and it's something we're going to have to keep an eye on because some of the ideas that were floating around it didn't reassure me. That's basically all I have.
Just on the note, I mean, there's fishing creeks in Lakeport too, and it flushes right into Moonshine Bay, so whatever happens upstream is
It comes right down.
Keep downstream. All right, Commissioner Sapp.
Well, one thing I'd like to, Ms. Bouchon, I want y'all to be, your department to be aware of this north of Moorhaven. Past the KOA campground, there's people on the left, they're rebuilding a junkyard.
Yes, we realize that, yes.
I mean, you know, when you drive along there, you don't really pay attention. You see that few things there, but when you look to the back, it's building, so we gotta get on that. And just for everybody's information, I'm sure a lot of you know the Medlock campground sold, and everybody's got to get out there. And there are several veterans in there that's going to be in trouble. And I've talked to 2 campgrounds in Palmdale to see if they would take one in, anything. So if y'all, anything to do for the veterans, maybe help us find a place, it would be greatly appreciated. And we got a little trash pile out there at Palmdale. The trash actually is on U.S. Sugar's property. I talked with them. And they're going to move a gate maybe up closer to the road so our illustrious truckers from Miami can't drop in there and dump stuff off. But I'm going to have to see if Archie can go out there and load this trash up and get it out of there. So I had a fire last night in Palmdale, and the man lost his camper trailer. No one was hurt. We finally got our fire truck cranked and got down there. But we had 5 young men respond and want to be part of our volunteer fire department, so that turned out good. So
that's it. Commissioner Sapp, Meadowlark, what are the plans that they're not?
I have no idea.
I haven't heard.
Oh man, it's been there forever.
That's what I was.
Anybody, June, y'all know anything?
I have not heard anything.
I've seen it on Link News, that they're evicting everybody in the, that's temporary, I guess, recreational vehicles is what they're, and supposedly according to the news, they're gonna put in a high dollar RV park there, and they don't want that in there, but, I got the letter from the lady with the veterans too. I know Aruba Park has a lot of vacancies in it, I don't know, but I don't know if they're asking, most likely the trailers that these guys are living in are probably not movable anymore. They've probably been there forever. So, and I talked to June a little bit. We're going to look at maybe the SHIP fund who might be able to help them some. But I know we do have $15,000 in there that our budget to hire a liaison or whatever, a
Veteran service officer.
A what?
A veteran service officer.
Veteran service officer, but it's kind of hard if you go and give $1,000 to a veteran, then what about all the other people that are living in that park? So, I mean, we just don't have enough money to take care of every one of them. So, I mean, I feel for the veterans, I mean, but it's just hard to, how can you exclude one from the other, you know? So, and I'm sure I don't know how many people are being evicted, but just what I've seen on the news. So. Ms. Taylor?
I don't have anything today.
Oh, really?
Well, I addressed my concern earlier.
I don't have a whole lot. I think 16 County Coalition's meeting the first Friday in September, something like that. But Lakeport's got a meeting tonight at 6:30, I believe, or 6.
6.
But we're getting real close to the election. I don't know how many people will show up this meeting, but we're getting there. But I don't know of any other. I'm glad that we're doing this comp plan. That'll be good. And I think we need to really look at our future land use too, so that we're not spreading all over. We need to keep our housing within the areas that are already there instead of like, we don't need to start another village. We already got 6 of them we can't take care of. So, but other than that, that's all I've got. Anybody else got anything?
One more thing, the VFW, they had kind of a reopening, I guess, for the season on Saturday. It was a decent turnout, but hopefully it gets more people supporting it. It's a pretty good deal. You don't have to be a resident or a veteran to participate in their dinner sales and things. So it just, you'll meet a lot of different people. It's a good organization to support.
Anything else? If we're all done, we are adjourned at 1 o'clock.